Ladies and gentlemen, it is my absolute pleasure and privilege to welcome you all to the Indian Council of Arbitration's 4th edition of the International Conference on Arbitrating Indo-UK Commercial Disputes, ADR, as a catalyst for strengthening the India-UK economic partnership. Ladies and gentlemen, for over 6 decades, the ICA, India's premier arbitral institution, has been at the forefront of promoting institutional ADR, fostering international collaboration and strengthening India's dispute resolution ecosystem. It is therefore particularly fitting that this conference is being held during the London International Disputes Week 2026, where the global disputes community comes together to shape the future of international arbitration. As we open the inaugural address, the session, I take this opportunity to invite someone who brings with him a wealth of experience flowing from the confluence of law, policy advocacy, and the advancement of institutional arbitration in India. Ladies and gentlemen, it's my privilege to welcome Mr. Arun Chawla, Director General of the Indian Council of Arbitration and former Director General, Federation of Indian Chambers of Commerce and Industry, to deliver the welcome address.
Thank you. Thank you, Akshita. Ladies and gentlemen, distinguished guests, good morning. I'm extremely delighted to welcome you to this 4th edition of ICA's Conference on Arbitrating Indo-UK Commercial Disputes. Hundreds of registrants to this conference, and many of them have come as special invitees. That is the testimony to the significance of this conference, the theme of which is ADR as a catalyst for strengthening Indo-UK economic partnership. It reflects the growing strategic convergence between the two nations, deeply connected by history, commerce, legal traditions, democratic institutions, and increasingly by a shared vision for the future of global dispute resolution. And ladies and gentlemen, what a privilege to have as the chief guest someone who presides over the largest judicial setup in the world, Honorable Mr. Justice Suryakant, Chief Justice of India. A jurist of exceptional distinction, Justice Suryakant has consistently championed institutional integrity, judicial efficiency, and access to justice. His contribution to strengthening India's arbitration jurisprudence and reinforcing judicial confidence in ADR mechanisms have been both visionary and transformative. Sir, your presence is a matter of immense honor for us. Ladies and gentlemen, this conference is to share perspectives of both the nations. Lending the might from the UK side is the Right Honourable Sir Geoffrey Vose, Master of Rolls and Head of Civil Justice of England and Wales. Thank you so much, Sir Geoffrey, by your benign and valuable presence in this conference. Your leadership on technology-enabled justice systems, procedural innovation, and modernization of civil justice deeply influences the legal systems across UK. So we are delighted to welcome you. Ladies and gentlemen, we are equally pleased to welcome Mr. Karthik Pandey, Deputy High Commissioner of India to the United Kingdom, an accomplished diplomat and extensive international experience. Mr. Pandey has contributed significantly towards strengthening India-UK relations across economic, strategic, and institutional dimensions. We welcome him with enthusiasm and look forward to his valuable insights. Ladies and gentlemen, we are also privileged to welcome Mr. Brett Dixon, Vice President of the Law Society of England and Wales, a highly respected solicitor, mediator, and legal professional. Mr. Dixon brings with him deep expertise in civil litigation, mediation, and legal innovation. We look forward to his perspectives on strengthening professional cooperation and enhancing access to justice in an increasingly interconnected commercial world. A very warm welcome to you, Mr. Dixon. Ladies and gentlemen, such a star-studded gathering of dignitaries on the dais. Please once again join me in extending a very warm welcome to all of them. Ladies and gentlemen, we meet today at an extraordinarily consequential moment in global economic history. The world around us is undergoing profound transformation. Supply chains are being reconfigured, technology is redefining commerce, geopolitical alignments are shifting, and capital is moving more cautiously. So businesses across the world are navigating increasing uncertainty. Yet, amid all this change, one foundational principle remains constant. Commerce flourishes where there is certainty. Certainty in rules, certainty in institutions, certainty in enforcement, and above all, certainty in dispute resolution. It was Lord Mansfield in the landmark English decision of Vergeo versus Wheeler in 1774, who famously observed that in all mercantile transactions, the great object should be certainty. This is precisely, ladies and gentlemen, why arbitration today occupies such a central place in the architecture of global commerce. International arbitration is no longer viewed as an alternate mechanism for resolving disputes. It has evolved into an enabling framework for economic cooperation itself. It gives businesses the confidence to transact across borders, across legal systems, across currencies, and increasingly across geopolitical uncertainty. So in many ways, arbitration has become the silent infrastructure of globalization. Invisible perhaps to the public eye, but indispensable to the functioning of international conference. And nowhere is this more relevant than in the rapidly evolving India-UK economic corridor. Ladies and gentlemen, the India-UK relationship today is entering a new phase of strategic and economic maturity. As discussions around the India-UK Comprehensive Economic and Trade Agreement continue to gather momentum, bilateral engagement between our two nations is deepening at an unprecedented pace. Trade is expanding, investment flows are strengthening, professional services are becoming more integrated, digital commerce is accelerating, and collaboration across sectors from infrastructure to technology, energy, finance, healthcare, manufacturing, and innovation is growing rapidly. Naturally, as commerce expands in scale and sophistication, disputes too will evolve in complexity. And that is not unusual. In fact, sophisticated economies are not defined by the absence of disputes. They're defined by the quality, efficiency, credibility of the systems through which disputes are resolved. That is why both India and UK are investing so significantly in strengthening their arbitration ecosystems. The United Kingdom continues to remain one of the world's most respected arbitration jurisdictions. India is simultaneously undergoing a remarkable arbitration transformation. Through legislative reform, judicial clarity, institutional strengthening, and growing policy support, India is steadily positioning itself as a serious and credible global arbitration jurisdiction. Importantly, the Indian judiciary has embraced a distinctly pro-arbitration approach, reinforcing party autonomy, minimizing excessive judicial intervention, and promoting enforceability and efficiency. It reflects a deeper national vision, a vision where India's growing economic stature is complemented by equally robust legal and dispute resolution institutions. It is in this broader context that the Honorable Chief Justice of India has often articulated the aspiration of making India a global hub for international arbitration. Ladies and gentlemen, today's conference is therefore both timely and important. Over the course of the day, we will deliberate on some of the most pressing questions shaping the future of international commercial dispute resolution. How do we build more efficient cross-border ADR systems? How do we strengthen institutional cooperation? How do we harmonize procedural expectations? How do we make arbitration faster, more enforceable, technology-enabled, and commercially responsive? And importantly, how do we ensure that ADR continues to evolve alongside the changing realities of global commerce? The discussions today will undoubtedly contribute meaningfully to that larger global conversation. Ladies and gentlemen, before I conclude, I would like to acknowledge the presence of several distinguished guests, including members from the Ministry of Justice, UK, the Law Society of England and Wales, the Commercial Bar Association, RICS, and our affiliate partners, the Blackstone, 39Essex, Trilegal, the JSA, PwC, and of course the media partners, the Bar Bulletin, Bar and Bench, SSC Online, and the bars across. My sincere apologies if I have inadvertently missed acknowledging anyone individually. And with these words, it is now my privilege to invite Dr. N.G. Khetan, President of the Indian Council of Arbitration and Senior Partner, Khetan & Company, to deliver the opening address. Thank you.
Good morning, London. Good morning. My good friend, Mr. Chawla, has introduced all our distinguished guests present on the dais. But I want to thank you all. I want to thank you, and I really want to thank you to be here in such a large number. Thank you very much for being here this morning. Thank you a lot. Thanks a lot. I'm told that in this arbitration week, the most popular event is the event organized by Indian Council of Arbitration. We have the largest number of gathering in the seminar, though it is held in the last day, but the highest number of attendees are from the seminar where Indian Council of Arbitration is holding. And why so? Because of your interest in India and because of your interest in the Chief Justice of India being present here. Sir, in last 5 years, we have held 4 international conferences here. All the conferences were addressed by the Honorable Chief Justices. We had the Honorable Law Minister also here on all the conferences. Unfortunately, because of some urgent engagement, he could not be present today. But why an interest in India? The interest in India is because today we are the fastest growing economy in the world. While the world is growing at the rate of 2 to 3%, India is still growing at the rate of 6 to 7%. We have the third largest consumer market in the world. And by 2030, our per capita income will touch $4 trillion, which on a purchasing power parity will be $12 trillion. So look at the amount of economy, look at of development India is doing. You know, we call it 30-30-30. That is the power of India. And what is that 30-30-30? The 30-30-30 is the people are under 30 years of age. They will continue to remain 30 for next 30 years. And in the next 30 years, we will have the $30 trillion economy. That's the power of 30-30-30, which India possesses today. Sir, I was just reading the interest which we are generating all over the world. You will be surprised to note that 163 Indian companies are operating in USA and are employing 4,25,000 workers. And there are 4,654 Indian-founded startups in USA today. What about Britain? It's no less. We have the highest number of Indian diaspora in Britain, the largest number of students in Britain. We have an FTS with Britain. Our import from Britain to India, 99% of the goods will be free of tax. Same thing with the situation when we'll be importing from Britain. We are a member of BRIC country, which has 10 members and 10 partner members with a combined turnover of $60 trillion. The FTS, which we have entered into with so many countries, have a combined turnover of $60 trillion, half of the world's GDP. Absolutely outstanding. I mean, why people are entering into this free trade agreement with India? It is because they are now believe in India. They have trust and confidence in India. And that is the trust and confidence which I see here. Why so many people are here. Now, the whole issue was that when we come to UK, what is the purpose of coming to UK? The purpose of coming to UK is also to promote arbitration in India also. Because there's got to be a lot of trade, commerce, business between UK and India now, between BRIC countries and India now. England has always been a Mecca of arbitration. In fact, you taught us the arbitration law. I mean, I was really surprised that, when I was reading that, when did India get the arbitration law? We are controlled by Britishers. And the first arbitration law which you gave us was the Bengal Regulation Act, which was in 1781. So this was the first codified arbitration law, which you all gave us to India in 1781. And then you gave us the Arbitration Act in 1840, you gave us in 1899, you gave us in 1940. So you taught us what arbitration is all about. I joined my profession in 1970, and we used to cite All England reports all the time. It was never, very few occasions we used to cite SCC. It was All England reports. We used to cite Paddington, we used to cite Gore, Brown and Company law, we used to cite Chitley. I mean, my office is a full library of English books, textbooks, and that's what the English, judges in India wanted to know. We have developed now, and today our judgments are cited not only in India, but are in different parts of the world. That's how we have grown. Our law has grown. We have the second largest number of lawyers in the world. Today our judges occupy foreign seats also. I mean, I can only tell you that it's a India, which is a new India, it's a golden India. In this divided world, I mean, we see this totally polarized world and a divided world. Which country you think is a safe haven to do business? If you really think about it, I think your mind will go to India, one of the safest places to do business in the world. One of the safest places to do in the world. I mean, I always believe that, you gave us the codified arbitration law, but we have been arbitrating for decades and decades and decades. And our arbitration was basically conducted in a very informal manner. In villages, in towns, when the codified law was not there. by the head of the family, the head of the villagers, and still that practice goes on. But one thing I want to tell you, that how we have grown and how we have developed, and this is an astonishing figure, that between 2016 to 2025, we were able to resolve 800,000 cases, 800,000 cases through mediation, through local adalat. An astonishing figure. You know, I think our first conference was in 2022, and Justice Ramanna was here, the Chief Justice of India was here, and I still remember a few of his quotes, which I thought I must say what he said. And he said that the Indian courts are known for their pro-arbitration stance. He went on to say the courts in India assist and support arbitration. Then he went on to say, in this era of instant noodle, people expect instant justice. Then he went on to say, the speedy justice is imperative for functioning of a healthy democracy. This is what our Chief Justice said in the first conference. And today, we have our Honorable Chief Justice of India, Justice Suryakant, with us. Practically every week, he goes to different weekends, I think he goes to different organizations, speaks there, speaks about the growth of the development of India, how the judiciary is working, how do we provide speedy justice, how should we promote arbitration, how should we promote mediation. And I would like to present before you some of his important quotation. In fact, a quotation which he recently made when he was addressing the Paris International Chambers of Commerce. And his main quote was that the mediation must be preferred mode of delivering justice, not the last resort. This is what our Chief Justice said. Thank you very much, sir, for that statement. Then he went on to say that India has a business-friendly legal system. Then again he went on to say that the court should not hurt investment climate. It should be pro-investment. We should promote investment. And we should not do anything which will hurt investment climate in any manner whatsoever. That is what the Chief Justice of India said in different seminars, not in India and also in outside India. Then when he also went on to say, this is a very revolutionary statement, that apart from capital and industrial policy, the resolution of commercial dispute will help India to achieve $10 trillion economy. This is what our Chief Justice feels. Unfortunately, our Law Minister is not here because of some urgent meeting, but I can tell you what he has done for this country. He has recently repealed 1,500 obsolete laws. He has decriminalized provisions under the Companies Act. Our laws have been made reformative. Outdated provisions have been removed from central acts. So why not think India as a venue to arbitrate? The cost of arbitration would be maybe 20% of what the cost of arbitration would be in England or London today. ICA would provide the cheapest arbitration, one of the cheapest arbitration. We now allow foreign lawyers to come and arbitrate in India and do non-litigation work. So you are all allowed to welcome and practice in India. And another most important factor was that the timely justice is our ultimate goal. And I'll give you just one illustration which happened a week back. Our Chief Justice delivered a judgment and he said, in a bail matter, the order must be uploaded on the same evening. If you hear the bail matter, the order must be passed and it must be uploaded in the same evening. Matters which are heard before the judges and are done CAV, the judgment must be pronounced within 30 days. This is what the Chief Justice has directed just a week back, sir. Thanks for that, sir. Thank you very much for making that. So what is our ethos? And what is our heritage? To me, our ethos and heritage is that if you had been right, you shall succeed. So whatever is right shall prevail. To me personally, to arbitrate is a divine function. In India, arbitration is an emotion. It's just not business. It's an emotion. We are a country which is creditable, we are honest, and we are trustworthy. And I would beseech all of you present here to try India, to test India. You all love Indian food, I know. But taste India to do arbitration there. Thanks a lot. Thank you very much.
Thank you, Khaitan sir, for your insightful remarks and for giving us an inspiring start to today's deliberations. Ladies and gentlemen, may I now invite the Vice President of the Law Society of England and Wales, the statutory and regulatory body representing solicitors across England and Wales. In his leadership role at the Society, he is uniquely placed to offer practical perspectives on the legal and commercial synergies between the two jurisdictions. Mr. Dixon, may I now invite you to deliver your address, please.
There we go. That's more like my height. Good morning, everybody. Thank you, Mr. Arun Chawla, Director General of the Indian Council of Arbitration, for inviting me to speak to you all here today. It's an honour to share the stage with so many distinguished guests. For those I've had the pleasure to meet before, I'm Brett Dixon, the Vice President of the Law Society of England and Wales. I will become President in October of this year. In many ways, it's similar to one of those deadlines in dispute resolution that you just know there is no extension for and you are going to have to comply with. But the Law Society itself is the representative body for around 210,000 solicitors who are qualified to practice English and Welsh law. We are a very international profession, with over 10,000 of our members based outside the UK in numerous jurisdictions. Our current president, Mark Evans, has recently returned from an official visit to New Delhi, where he met with many members of the Indian legal fraternity, including some of you here today. I know he found the visit incredibly interesting and valuable, and found your hospitality, just as today, to be unfailingly very generous. India is a hugely important jurisdiction for the UK. It goes without saying that the suite of free trade deals India has recently signed signals that you are a confident, outward-facing nation ready for significant economic growth. The signing of the UK-India Free Trade Agreement last year was hugely meaningful for both nations. Although legal services didn't make it into the final text, the FTA is a positive step forward for future relations between our two countries. India and the UK have strong cultural, historical, and legal ties. These are evidenced through events like we have here today, which are incredibly important for maintaining these links and realising our shared potential together. As you know, harnessing the power of the legal sector is key to ensuring economic growth and prosperity for both of our nations. Alternative dispute resolution is an important part of that story. It plays a vital role not only in resolving disputes, but in underpinning business confidence, facilitating cross-border investment, and enabling long-term commercial partnerships to flourish. As trade between the UK and India continues to grow, so does the need for trusted, efficient, and internationally recognised dispute resolution mechanisms. As we all know, businesses are much more likely to invest where there is certainty, predictability, and confidence in how their disputes are handled. India has already taken some very important steps to position itself as a leading arbitration hub. And this is something the UK strongly welcomes. But there is a real opportunity to build on this momentum, further strengthening India's dispute resolution ecosystem, whilst deepening collaboration with international partners like ourselves. Closer alignment, greater engagement between our legal sectors, including through arbitration, mediation, and professional exchange, can act as a powerful catalyst for trade, innovation, and mutual prosperity. At the Law Society of England and Wales, we regularly engage with UK and Indian governments, as well as with other trade and professional bodies, to promote collaboration and knowledge sharing between our two jurisdictions. The UK's open legal sector allows Indian lawyers to practice in a range of areas, establish an office, and work alongside UK qualified lawyers. The international reach of legal services is highly important for the global impact of our sector, acting as a facilitator for growth and supporting trade, investment, and the ease of doing business. Here in the UK, we greatly benefit from the contribution of lawyers from India. We are privileged to gain the skills and expertise from those qualified in other jurisdictions. The contribution of international lawyers supports consumer choice, improved business outcomes, and facilitates inward investment. Experience here in the UK has shown us that an open and collaborative approach to legal services creates an environment that not only strengthens our domestic capability, but also enhances the attractiveness of the jurisdiction as a global centre for dispute resolution and commercial activity. I have no doubt that India can also benefit in a similar way as it continues to grow into one of the world's largest economies, particularly as it seeks to consolidate its position as a leading destination for international arbitration. The Bar Council of India's announcement in May last year confirmed the implementation of the amended regulations for foreign lawyers and law firms, and marked a significant and welcome step forward in opening up the legal sector. However, there are a few challenges, and we are currently engaging in a fruitful dialogue with the Bar Council of India and the Indian government to find a mutually beneficial solution which works in practice for both of our countries. Addressing these practical questions will be the key to unlocking the full potential of the reforms and ensuring that these deliver the intended economic and professional benefits. The UK is and will continue to be an open jurisdiction. International lawyers contribute greatly to the England and Wales status as a world leader in the provision of legal services. We firmly believe that open, collaborative legal ecosystems, which are underpinned by strong dispute resolution frameworks, serve not only the legal profession, but the wider economy. They build confidence, They reduce friction and help businesses from all sectors to grow and innovate across borders. As India continues its economic rise, and as our two countries deepen our partnership, there is a real opportunity here for us to further strengthen the ties between our legal sectors, building on the progress we have already made and unlocking even greater potential for collaboration. I can tell you, as I move into my presidential year, the Law Society, as ever, stands ready to work closely with key stakeholders across the professions to support this dialogue and journey. Whether we do that through dialogue, knowledge sharing, or other practical cooperation, we are there for all of us. By working together, we can ensure that our dispute resolution systems not only respond to the needs of today's global economy, but actively help to shape the future of both the Indian and the UK legal profession. So thank you very much for your time today, and I hope I took as little of it as possible, but it was useful for you. Thank you very much.
Thank you, sir, for your thoughtful address. Your perspective, reflecting the practicalities faced by the British Bar, has laid a strong foundation for the discussions ahead. Ladies and gentlemen, diplomacy lays the foundation upon which strong commercial ties are built. We eagerly look forward to hearing the perspectives of India's Deputy High Commissioner to the UK on the India-UK partnership in this evolving geopolitical and economic landscape. I therefore invite Mr. Kartik Pandey, Deputy High Commissioner of India to the United Kingdom, to share his special remarks, which we are confident will greatly enrich the deliberations.
Thank you. At the outset, good morning to everyone here. Honorable Chief Justice of India, Justice Surya Kant, the Right Honorable Sir Geoffrey Voss, Master of Rolls and Head of Civil Justice of England and Wales, Mr. Brett Dixon, Vice President of the Law Society of England and Wales, Dr. N.G. Khaitan, President ICA, Mr. Arun Chawla, DC ICA, distinguished guests, ladies and gentlemen. First and foremost, I would like to express my sincere appreciation on participating in the 4th edition of this International Conference on Arbitrating in Indo-UK Commercial Disputes, organized by the ICA. This conference, as we all know, has established itself as an important platform for advancing dialogue on cross-border dispute resolution and strengthening legal cooperation between India and the UK. We are indeed honored by the presence of the Chief Justice of India, Honorable Justice Surya Kant, the Right Honorable Sir Geoffrey Voss, Mr. Brett Dixon, among other dignitaries, and I, for one, in fact, look forward to listening to their valuable perspectives that they will bring to today's discussions. Distinguished guests, to me, today's event can be profitably situated in the background of the remarkable growth of the India-UK economic and investment partnership. And at the outset, let me also say that most of what I am going to say has in various forms already and very clearly been said by the speakers before me. The past year has been particularly significant. We witnessed 2 prime ministerial level engagements in quick succession. These exchanges are in fact emblematic of the strength, maturity, and growing strategic importance of the bilateral relationship. Today, trade between India and the UK stands at approximately 47.9 billion pounds. For many years, the ambition of doubling the bilateral trade by 2030 appeared aspirational. Today, it appears today it appears entirely within reach, and there are good reasons for that. Also, the significance of the free trade agreement signed last year extends far beyond tariff reductions. It introduces modern digital customs framework, streamlines rules of origin, enhances transparency, and enables businesses to move goods more efficiently and at lower cost. In doing so, it creates the conditions for deeper economic integration and greater commercial confidence. On the investment front as well, India and the United Kingdom are increasingly emerging as balanced and dynamic partners. Investment flows are becoming more reciprocal, reflecting growing confidence in each other's markets and long-term economic prospects. This deeper engagement is in fact assisted by institutional mechanisms such as the India-UK Economic and Financial Dialogue, co-chaired by the respective finance ministers, the India-UK Infrastructure Financing Bridge, launched in partnership with the Niti Aayog and the City of London, which leverage London's strength in sustainable and green finance to support critical infrastructure development across India. India's investment environment, as I think also was alluded to earlier, has also undergone a significant transformation in recent years. Through sustained economic and regulatory reforms, including the PM Gati Shakti, the National Logistics Policy, expanded public-private partnerships framework, asset monetization initiatives, and reform in taxation, labor, foreign investment, and trade policy, India is creating a more transparent, efficient, and investor-friendly ecosystem. These reforms are laying the foundation of sustained growth and deeper integration with global markets. Ladies and gentlemen, the commercial engagement between India and United Kingdom, as it continues to expand, the importance of effective and trusted dispute resolution mechanisms becomes even more pronounced. Businesses and investors seek certainty, predictability, and confidence that commercial disputes, should they arise, can be resolved fairly, efficiently, and in a manner that supports continued business relationships. Robust arbitration and alternative dispute resolution frameworks provide precisely that assurance. They help create a stable partnership and environment for international transactions, reinforce contractual confidence, and facilitate increasingly complex cross-border commercial activity. Recognizing this imperative, the Government of India remains firmly committed to promoting alternate dispute resolution mechanisms, including arbitration and mediation, as an integral part of our legal and commercial ecosystem. In the above background, strengthening of legal cooperation between India and the UK makes a case for itself, and I'm certain that today's proceedings will touch upon the various aspects of the matter. Before concluding, in fact, I would also like to state that the ICA, in fact, deserves particular recognition for its effort in bringing together practitioners, policymakers, academics, institutions, and from both jurisdictions. The example we see today, we welcome you all to London. I'm also confident that today's discussion will generate meaningful insights and further strengthen our shared commitment to building a modern, efficient, and internationally respected dispute resolution framework in India that supports both the growing economic partnership between our countries and global resolution of disputes. I, for one, definitely look forward to listening to the Honorable Chief Justice and Sir Geoffrey Bose. Thank you very much.
Thank you, sir, for your insightful address. Ladies and gentlemen, we are privileged to have with us today Right Honourable Sir Geoffrey Bose, Master of the Rolls and Head of Civil Justice of England and Wales. Sir, your presence lends great distinction to this gathering, and we look forward to your insights into the future of arbitration and judicial support for international commercial arbitration. Please join me in welcoming Sir Geoffrey Bose while I invite him to deliver his keynote address.
Honourable Chief Justice of India, ladies and gentlemen, thank you so much for inviting me to contribute to this extremely important conference. I've been asked to address the subject of strengthening the India-UK economic corridor, the role of ADR in cross-border trade and investment. And I've actually visited India on more than a dozen occasions in the last 25 years. And on each occasion, I go to India I visited courts in Mumbai, Kolkata, Delhi, and all over the country. And I've also had the privilege of being shown at first hand the immense efforts that are being made to digitize the Indian courts. I had the privilege of spending a day sitting with the former Chief Justice Chandrachud in the Indian Supreme Court in late 2024, and I observed the extensive usage of AI by the Indian judiciary, including in producing simultaneous transcripts of the proceedings. And I know that Chief Justice Surya Kant is continuing this process enthusiastically. You will know that I have been intimately involved too, as head of civil justice here in England and Wales, in the digitization of the justice system of England and Wales, and in the creation of our digital justice system, which aims to resolve all kinds of dispute online without the need for lengthy and costly analog legal proceedings. I believe that close, friendly relations between the major common law jurisdictions of the world is becoming increasingly important in the new digital world in which we live. And in this short address this morning, I'm going to try and explain why that is the case and why these relationships are equally important to international arbitration in our two countries. But let me start, perhaps eccentrically, by referring, if I may, here in Church House, to Pope Leo XIV's encyclical last week entitled Humanita Magnifica, on safeguarding the human person in the time of artificial intelligence. Much of it is about the critical subject of digital sovereignty. Paragraph 67 of the Pope's encyclical says that its context is where the wealth of nations depends increasingly on knowledge and technology. And when these goods remain concentrated in the hands of a few without adequate forms of sharing and access, a new imbalance, he said, is created. And he talked of the widening gap between the included and the excluded, and called for the new possibilities offered by technology to be regulated in such a way as to respect the environment, avoid waste, and prevent new forms of exploitation. It seems to me that the Pope was speaking of two forms of digital exclusion: the exclusion of many nations from their own digital sovereignty, and the exclusion of many of the world's population from the economic advantages afforded by ever more capable AI. And these two forms of digital exclusion are more than relevant to both India and the UK, because neither country is free of outside influence. The UK benefits from a linguistic advantage in that it can make full use of US-based LLMs and AI systems founded on the English language, whereas India has multiple languages, which create challenges for bringing large language models to the entirety of her population. But both countries are dependent on the technological sovereignty of big corporate developers in other countries, including, of course, the USA and China. Dependable systems of private law and efficient and economical commercial dispute resolution are both far more important to the economic success of our nations than many people would recognize. Let me explain what I mean. It has long been understood that reliable overseas investment in all our countries is dependent on the rule of law. Unless overseas investors are confident that a commercial dispute with the government of the home country will be resolved fairly, within a reasonable time, and at proportionate cost, such investors will go elsewhere. This principle applies as much to arbitration as it does to court-based dispute resolution. This principle also applies with even more force to the availability of AI. Our economies in India and the UK now depend on the availability of increasingly capable AI to all our industrial and financial markets. As the current international conflicts emphasize, global economies are fragile and can easily be disrupted and damaged by events. So there is perhaps a golden opportunity for our two countries to work together to ensure that our populations are not excluded from access to ever more capable AI, and that each of our countries can retain its own digital sovereignty, governed most importantly by our own domestic laws. Now, I'm sure everyone here will be aware that in December 2025, the AAA, the American Arbitration Association, its International Center for Dispute Resolution, launched an AI machine-driven arbitrator for two-party, document-only construction disputes. The AI arbitrator has a human in the loop in that the outcomes and draft awards proposed by the machine will be evaluated by a human arbitrator. But that human will review and test the AI's reasoning and evaluate the decision to safeguard trust, transparency, and due process. I don't think the AAA has yet published any analysis of the take-up of this process, but it's likely that it will be adopted because AI arbitration and AI-driven ADR have some considerable advantages over court-based dispute resolution by human judges. Those advantages, of course, are cost and speed. And AI-driven solutions of the kind I've mentioned are far easier to introduce in the arbitration context, where the parties have autonomy and where there's no judicial arm of state involved in the process. So it's worth pausing to note that AI-driven judicial dispute resolution is complex for reasons of constitutional and democratic legitimacy. It would not, as it seems to me to be possible, for the judiciary in any democratic country to use AI to make its decisions of its own volition, because it is a central tenet of the rule of law that the state provides an independent judiciary fairly to resolve disputes between citizens and between business and citizens and between them and the state. And it's not yet been established that a machine can constitute an independent and impartial tribunal for the purposes of, in this country, Article 6 of the European Convention on Human Rights, and in India, Article 14 of the International Covenant on Civil and Political Rights. We do, though, of course, see AI already being used to facilitate judicial decisions in China, Argentina, and Brazil, but not in many other countries where legislation would be needed to allow those decisions to be taken by AI. The crucial difference in ADR and in arbitration is that the parties can consent to resolve their disputes in any way they choose. And in arbitration, consent is usually given in a contractual context in advance of the dispute arising. So to return to my theme, if cross-border investment is to be promoted in the India-UK corridor, effective dispute resolution in general and arbitration in particular is critical for the reasons I've mentioned. It seems to me that the international legal community should be astute to ensure that the common law foundations for our alternative dispute resolution mechanisms are our domestic legal systems. If AI systems are to be used in arbitral decision-making, the underlying LLMs must be trained on materials that are relevant to the home states of the parties involved in the disputes. If AI is actually to take decisions or even to inform human decision-making as to the outcomes of cases, whether in ADR or in a judicial context, there has to be the creation of reliable models and LLMs that are trained for that purpose, and extensive testing of their reliability and biases in decision-making. It's possible that when we do have our first machine-made arbitral decision, there will be challenges to its enforcement under the New York Convention public policy provisions. Machine-made arbitral decisions, though, may become very attractive to commercial parties in terms of time and cost. But the legal community must ensure that the digital and legal sovereignty of our jurisdictions is maintained so that those decisions are just and reliable. Should we be worried from a rule of law perspective about these developments? Well, I think not, because it is one thing to impose machine-made decisions on parties to court proceedings who might justly claim a constitutional right to a decision made by a human judge. But it's another thing to allow the parties to choose a process that expedites their decision-making by which they've agreed to be bound. So let me conclude by suggesting, as I often do, sometimes without much effect, that the legal community must move with the times. As I said on Tuesday at the LIDW's main panel, none of these changes that I talk about frequently is likely to be reversible. The world will not go backwards. Instead, these changes will accelerate, and the legal community needs to find ways to make itself relevant in the new world order, to adapt and change. And in order to ensure that we encourage and promote cross-border trade, we must make sure that we embrace AI solutions to legal problems. But, as I say, and I think this is very important, those AI solutions must have their foundations in our own laws, in the laws of India and England and Wales, in our own legal traditions. If we are to adopt AI-assisted arbitral decision-making, we should train and test the AI tools we're using on materials that are relevant to the states of the parties involved in the disputes. Thank you very much for your attention.
Thank you, sir, for your erudite address. Your remarks have set a strong foundation for the discussions ahead. Ladies and gentlemen, we now arrive at a moment of great significance as the highest judicial authority in the country, Honorable Mr. Justice Surya Kant, the Chief Justice of India, presence here reaffirms India's pro-arbitration stance and the judiciary's evolving role in promoting efficient dispute resolution. However, before we invite him to deliver his address with his kind permission, we would first like to present a short tribute. Sir? Can we have the video, please?
In the service of justice, integrity is not a choice. It is a lifelong commitment. The Honorable Chief Justice of India, Justice Surya Kant, has dedicated decades to strengthening the foundations of India's judicial system. Beginning his legal career in 1984, he steadily built a reputation grounded in constitutional clarity, discipline, and judicial excellence. From serving as Advocate General for the state of Haryana to becoming Chief Justice of the Himachal Pradesh High Court. His elevation to the Supreme Court of India in 2019 brought decades of legal insight to the nation's highest court. Today, under his leadership, the Indian judiciary is witnessing a transformative phase focused on speed, accessibility, and modernization. Major reforms have been initiated to accelerate bail hearings and ensure that liberty is not trapped in endless procedure. Through the One Case, One Data initiative, courts across India are being integrated into one connected digital ecosystem. Technology is reshaping justice delivery, from AI-enabled systems to citizen-friendly digital assistance platforms like Su Sahay, with a strong emphasis on intelligent case management and pendency reduction. His vision also champions mediation and arbitration as effective pathways towards faster and more collaborative dispute resolution. At ICA's Chandigarh conference, his presence reinforced the growing importance of institutional arbitration in India's legal ecosystem.
The arbitration should assume and should work in taking over the role as an express highway. The toll tax may be, but that toll tax should be affordable so that the people prefer that highway. And once you are there on the highway, you must reach that destination as early as possible. That should be the philosophy of the arbitration.
And at ICA's Delhi 2026 conference, the dialogue further expanded around judicial modernization, arbitration, and the future of efficient commercial dispute resolution in India.
It is my proud privilege and a profound pleasure to inaugurate the 5th edition of ICA International Conference on Arbitration in the Era of Globalization, Legal Technology, Economic Development and Cross-Border Disputes. This conference brings together a sparkling consultation of judges, practitioners, institutional leaders, and policymakers from India and abroad, and that can very well be witnessed from this auditorium, as also the adjoining one, where about 300 more delegates, I am told, are watching this program. Such exceptional gatherings allow us to ruminate on how dispute resolution must evolve in response to a rapidly changing commercial landscape.
Through platforms like the Indian Council of Arbitration, the vision for a smarter, more accessible, and future-ready judiciary continues to take shape.
Ladies and gentlemen, please join me in welcoming Honorable Justice Suryakant with another thunderous round of applause as we invite him for the inaugural address.
The Right Honorable Sir Geoffrey Charles Boss, Master of the Rolls and Head of Civil Justice of England and Wales, Mr. Kartik Pandey, Learned Deputy High Commissioner of India to the United Kingdom, Mr. Brett Dixon, Vice President of the Law Society of England and Wales, Dr. N.G. Khaitan, President of the ICA, Mr. Arun Chawla, Director General ICA, eminent former judges and very eminent senior advocates from the Supreme Court of India, other parts of the country as well as from England, learned former judges, distinguished panelists, practitioners, arbitrators, and friends from the world of law and commerce, friends from media, ladies and gentlemen, I am truly delighted to be here at Church House to inaugurate the 4th International Conference of the Indian Council of Arbitration. At the very outset, I would like to extend my heartfelt appreciation to the ICA, the organizers, for bringing together such a distinguished gathering from the world of law, commerce, public policy, and dispute resolution. We meet at a significant moment in the relationship between India and the United Kingdom. May I just at the outset also point out that I am sharing my views with reference to the arbitration or the alternative dispute resolution mechanism as a catalyst for strengthening Indo-UK economic partnership. So in that context, I was saying that we meet at a very significant moment in the relationship between India and the United Kingdom. Ours are two common law jurisdictions with a long legal conversation between them. They are also two economies seeking to give fuller meaning to a deeper commercial partnership. This significant endeavor requires confidence that when disagreements arise, they will be resolved fairly, efficiently, and with respect for commercial realities. It is in that spirit that I wish to speak about arbitration today. Also, as head of the Indian judiciary, knowing fully well that we are facing one of the challenges of pendency, I am not only a big stakeholder in arbitration, but if you permit, I would say that I am a co-partner in the arbitration family. At its best, arbitration brings to commercial disputes expertise, neutrality, confidentiality, finality, and practical good sense. It is for these reasons that it has found acceptance across jurisdictions and legal traditions. Yet respect for any institution requires more than praise. I am thankful to the organizers that in a video clip they had shown my two previous participations on the ICA platform. One probably in 2019 and the other one was in 2026 only after I took over as Chief Justice of India. And in continuity only and being deeply concerned and deeply appreciating the arbitration as a very robust and effective mechanism which is addressing most of the commercial challenges in India and of course across the world, that some of the issues I thought that this is the intellectuals occupied platform where I should raise these issues. The arbitration, when we are referring to, it also requires us to ask with candor where it may have drifted from its founding purpose and what must be done to restore that purpose. But before I can assess what is lacking in international arbitration today and speak loftily about strengthening the UK-Indo ADR framework, we must first be clear about what it was meant to be. Ladies and gentlemen, arbitration did not begin as a creature of a statute. I know that all of you are aware, but I'm just refreshing the memories. It did not spring into life with the English Arbitration Act of 1889 or India's first arbitration legislation of 1899 or even the New York Convention of 1958. Those instruments merely recognized, regularized, and regulated a practice that commerce had already developed centuries. As the story goes, when medieval merchants of different nations met at the great trade fairs of Champagne, they could not rely on any single state's courts. They could not wait for expensive and formalistic litigation. They needed decisions quickly from people who understood their trade. And that experience gave rise to the Lex Mercatoria, or the law of merchants. And in India, I would say that instinct of community-based dispute resolution was even older. The ancient panchayat system, which placed its trust in the village elders, was resolving commercial disputes long before any arbitration statute came into existence. The principle was the same. Justice is most legitimate when it is chosen freely, delivered by someone who understands your world, and proportionate to what is actually at stake. Arbitration is simply what happens when you take this instinct and give it a framework. Its central question is simple. When parties in commerce disagree, how can their dispute be resolved in a manner that is fair, informed, timely, and final? All rules, institutions, and enforcement mechanisms exist to serve this central question. The difficulty begins when the machinery overwhelms the purpose. If arbitration becomes too expensive, too slow, too closed, or too formal for a parties it is meant to serve, then the institution must look within. Ladies and gentlemen, despite its many successes and millions of successful stories, international arbitration today faces a few structural challenges. I believe this has occurred at least in part because arbitration has increasingly come to be treated as a product to be promoted rather than a mechanism to be refined. At times, one is reminded of an automobile expo where every manufacturer is eager to showcase the virtues of its latest model. In a similar vein, institutions, practitioners, and stakeholders often compete to highlight the attractions of arbitration, sometimes with greater emphasis on its commercial appeal than on the practical objectives it was intended to achieve. The consequence is that the conversation can occasionally shift away from the parties and businesses whom arbitration exists to serve and towards the industry that has developed around it. For instance, in high-value international arbitration, appointment patterns have often appeared concentrated. A relatively small pool of repeat participants appears with frequency as arbitrators, counsel, and experts. This is not by itself evidence of impropriety, I must admit. Most of us would agree that expertise is often built through repetition, but concentration can create a strong perception that arbitration is distant and difficult for others to enter. The concern is visible also in the cost and duration of many proceedings. In some cases, international arbitration has absorbed the very habits of litigation that it was designed to avoid. Heavy pleadings, multiple procedural rounds, long hearings, and fee structures that many users find difficult to bear. Arbitration agreements, unfortunately, are at times drafted with a level of complexity that rivals a legal treatise. Instead of providing certainty, they frequently contain ambiguous language, overlapping provisions, and imprecise formulations that leave critical questions unresolved. The result is often a preliminary round of litigation devoted not to the merits of the dispute, but to determining foundational questions, namely, whether a valid arbitration agreement exists at all, which law governs it, where the jurisdictional seat is located, whether the chosen venue carries legal significance, and who possesses the jurisdiction to decide these issues. By the time these threshold questions are resolved, parties may find themselves engaged in extensive litigation merely to establish that their dispute is In fact, one that must proceed to arbitration. Similarly, the principle of party autonomy, which is often described as one of the defining strengths of arbitration, has in certain respects, in my humble opinion, come to be misunderstood and stressed beyond its intended purpose. Increasingly, one encounters situations where party autonomy is equated with an unrestricted ability to select particular adjudicators, a practice that can sometimes give rise to concerns regarding perceptions of neutrality and confidence in the arbitral process itself. In many common law contexts, comparable attempts to secure a preferable form of decision maker would attract close scrutiny, and it may amount to form shopping even. Yet within arbitral discourse, such practices are occasionally defended under the broad banner of party autonomy. In my view, this reflects a misunderstanding of the principle. Party autonomy was never intended to mean that parties are entitled to engineer the identity of the decision maker, most likely to favor their position. Rather, it signifies the right of the parties to insist upon a process that is independent, impartial, fair, and capable of inspiring confidence in its outcome. When disputes over appointment themselves become the subject of prolonged challenge before courts, the process begins to undermine the very efficiency and credibility that arbitration seeks to provide. It may therefore be worthwhile to consider whether clearer guidelines, institutional safeguards, or more developed doctrinal principles. Particularly, we need to strengthen the institutional arbitration that are required to ensure that party autonomy remains a guarantee of procedural fairness rather than a source of procedural contestation. What these issues amount to are a form of institutional self-consumption, which we must guard against. Arbitration was built to be the answer to the pathologies of formal litigation, and it is seemingly acquiring each of those very failings. In other words, the remedy has come to resemble the disease it was designed to cure. Therefore, my dear friends, that transformation did not happen in a day. And reversing it will also not happen unless we collectively commit ourselves towards that cause. It will require, for instance, organizations to champion the international adoption of best arbitral practices, conferences with timely themes like this that demand institutional reflection, and a globally collaborative approach among genuine and ethical platforms. Turning to the theme which I opted to speak, the ADR as a catalyst for INDO-UK business relationship. Just last year, the India-UK Free Trade Agreement was concluded, which was an unquestionably historic moment for both nations. Because at a time when international trade discourse is marked by strain and uncertainty, India and UK showed the world a better way forward. The FTA is expected to increase bilateral trade between the two nations, and as I was reading in a newspaper, by an estimated US dollar 34 billion a year by 2040. This is indeed an aspiration of extraordinary ambition. But ambitions are realized in contracts, not in communiques. The Indo-UK economic partnership cannot be strengthened by trade agreements, tariff schedules, and investment announcements alone. It also needs an ADR architecture that converts commercial confidence into day-to-day practice. And it is that apprehension of the structural failure which I just thought to highlight and describe that stand most directly between aspiration of the FTA and the commercial reality it is meant to enable. In the conference, the first session is very meaningful Because the first session today asks how ADR can strengthen the Indo-UK economic corridor. To my mind, the answer begins with confidence. A corridor is not strengthened merely because goods, capital, and services are allowed to move across it. It is strengthened when those who use that corridor know that if something goes wrong, they will not be priced out, delayed out, forced into a process that had no real power to choose. In many cross-border contracts, including those that will multiply under the FTA, smaller exporters, suppliers, startups, and medium-scale industries accept seats, rules, and fee structures chosen by stronger counterparts. So while their consent is legally valid, their practical choice is often thin. We must therefore introspect how to ensure equal level play field for all. This is not a peripheral concern, especially when we know that the next wave of Indo-UK trade will not be carried out by conglomerates. It will be carried by pharmaceutical suppliers, fintech firms, clean energy business, digital platforms, and mid-markets manufacturers on both sides. If our ADR mechanisms work only for disputes large enough to justify high fee or large legal teams, that might fail the very commercial partnership that are meant to support. Real party autonomy, therefore, requires accessible model clauses, transparent costs, diverse panels, digital case management, and procedures proportionate to the value and urgency of the disputes. In short, the autonomy that arbitration promises must be made genuinely usable for all parties to the corridor, not just the most powerful ones. There was a time when India's arbitration conversation was framed as an effort to catch up with London's gold standard. That framing may have become obsolete and even an obstacle to the very co-creation this partnership demands. Consider what has happened simultaneously on both sides. The English Arbitration Act 2025 recently received royal assent, concluding a 4-year process of modernization. India's Bar Council in May 25 amended its rules to allow foreign lawyers and firms to operate in India in varied sectors, opening the doors for the cross-fertilization of legal talent into the Indo-UK corridor needs. Our Mediation Act of 2023 gives India one of the most developed statutory framework for mediation enforcement in India, and the FTA itself has created the commercial impetus for all of these to cohere. These are signs of convergence between two mature common law systems that have each developed sophisticated, independently reasoned ADR cultures. What is needed now is not comparison, but co-creation. The task is to design together an ADR corridor that in which both systems lend each other credibility, talent and standards, ultimately building something neither could build alone. And this brings me to the second session of this conference today, which asks us to look beyond silos and architect hybrid ADR ecosystems for complex Indo-UK commercial disputes. I believe that question awakens us to the reality that it is not enough to have two parallel systems, each excellent within its own jurisdiction, running side by side without connection. What the FTA's commercial reality demands are hybrid mechanisms, arbitration mediation protocol that preserves commercial relationships rather than destroy them, joint institutional framework that build shared arbitration panels and digital platforms that make these mechanisms accessible to businesses of every scale. This is where co-creation must begin. With that goal in mind, allow me to suggest 3 concrete steps that are within the reach of the institutions I'm talking about the arbitral institutions representing in this room. First, build informed neutrality. Friends, geographic neutrality alone is no longer sufficient. A tribunal may be seated in London and still be unfamiliar with Indian regulatory realities, like medium standard entrepreneurs, contracting practice, or the significant jurisprudential developments of the last decade in Indian commercial law. Likewise, a tribunal in India may misread English commercial expectations. I therefore believe that a joint Indo-UK arbitrator accreditation and cross-training program should build a shared pool of practitioners genuinely fluent in both ecosystems and begin directly to dismantle the exclusivity I described earlier. Second, create a swift track protocol for the missing middle. The FTA will generate disputes, maybe relating to technology licensing disputes, fintech partnerships, breakdowns, and so on. For these, institutional arbitration framework should be suitably provided, and that platform should be something which is acceptable and affordable by all of them. This will require a capped fee, a primary documentary procedure, online hearing where appropriate, a short mediation window, and a defined timetable for final determination. And the third suggestion is connect arbitration with mediation through properly designed hybrid protocols. Many Indo-UK disputes will arise within continuing relationships, joint ventures, distribution networks, technology partnerships, infrastructure contracts. In all such relationships, the best outcome is often not a winning award, but a preserved commercial relationship. India's Mediation Act 23 and the growing mediation culture in the United Kingdom give us every foundation we need to build protocols that are properly safeguarded for confidentiality and impartiality. Let me conclude by reiterating that arbitration does not need another ceremonial tribute to its past. It needs a serious recommitment to the reason it came into being. Contemporary international arbitration asks parties for a profound act of trust. When they step away from their national courts and submit their disputes to a private tribunal, they are entitled to expect a process that is fair, proportionate, and timely. They are entitled to expect that the tribunal will understand the dispute, that the procedure will not overwhelm it, and that the award will bring certainty. That is why, and I said in the beginning, the merchants of champagne will still matter. They did not wait for a perfect institution or a perfect legal order. They built what commerce needed with the tools available to them, because unresolved disputes, broken trust, and stalled trade were too costly to tolerate. The same insight animated many of our own local traditions of settlement in India. Today, our task is similar. We must ensure that arbitration is not a privilege of scale, but an instrument of justice. And of this conference helps move us even modestly in that direction. It will have served a purpose beyond deliberation. And I know the participants, the stakeholders, the leaders of ICA, that they're being committed to these issues to bring affordability, timeline, certainty, productivity in arbitration, that I chose to flag these issues before all of you. I congratulate the ICA for organizing such a meaningful deliberation. I hope that the technical sessions will undoubtedly address those issues which I have tried to raise before you and will respond with befitting answers. With this, I take your leave and wish the deliberations of this conference a very success. Thank you very much for inviting me and giving this opportunity to share my views. Thank you very much. Thank you.
Thank you, sir, for your profoundly sagacious and illuminating address. Your remarks have set a very authoritative foundation for the deliberations that follow. As the inaugural session culminates, I once again invite Mr. Arun Chawla, Director General, ICA, to deliver the word of thanks.
Ladies and gentlemen, fabulous statements from both the sides. Convergence in systems of dispute resolution becomes inevitable. Ladies and gentlemen, today's statements reflected something far deeper than ceremonial addresses. They reflected a shared recognition that the future of global commerce will increasingly depend not merely on economic ambition, but on institutional collaboration and trust. And at the center of that trust lies the rule of law, commercial certainty, and credible dispute resolution. So, ladies and gentlemen, we have heard powerful reflections from the bench, from policymakers, from the legal profession, from diplomatic leadership, each approaching the India-UK partnership from a different vantage point, yet arriving at a remarkable common conclusion that modern commerce cannot flourish without reliable systems for dispute resolution. As the CGI said so succinctly, that justice is best delivered when parties choose a system of resolving disputes. Arbitration is naturally the most important and potent mechanism for resolving disputes, commercial disputes. Increasingly, the becoming foundational instruments of economic governance itself, and I must say, they're quietly shaping the investor confidence, reducing friction in cross-border commerce, facilitating long-term commitments. In many ways, this is where the India-UK partnership assumes particular significance, because our relationship is unique, positioned at the intersection of shared legal traditions and future economic opportunity. Common law foundations, strong democratic institutions, deep professional linkages, highly sophisticated legal communities, and increasingly integrated commercial interests. Together, these create fertile ground for building one of the most consequential dispute resolution corridors in the global economy. And as the India-UK Comprehensive Economic and Trade Agreement progresses, this conversation becomes even more important. This is precisely why legal certainty is increasingly becoming a form of economic infrastructure. Much like ports, logistics, digital connectivity, or financial systems, credible dispute resolution frameworks now influence where businesses choose to invest, expand, manufacture, innovate, and collaborate. And perhaps nowhere is this more relevant in the context of cross-border trade investment between India and the United Kingdom. As the Master of Roles, Sir Geoffrey Vos, said, this is the golden opportunity for the two countries and the legal communities to come together to create a seamless dispute resolution system. So, ladies and gentlemen, today's inaugural session is therefore set an exceptionally thoughtful and intellectually rich tone for the conference ahead. On behalf of Indian Council of Arbitration, I would like to express our deepest gratitude to our distinguished dignitaries for honoring us with their presence and sharing their valuable perspectives. Our sincere thanks as well to the media, professional institutions, and members of the arbitration community whose continued engagement helps strengthen global dialogue on ADR and commercial justice. Ladies and gentlemen, as we move into the technical sessions ahead, we do so with a deeper appreciation of an important reality, that the future of commerce and the future of dispute resolution are becoming increasingly inseparable, because where there is certainty, commerce expands. Where institutions inspire confidence, investment flows. And where dispute resolution systems are trusted, economic partnerships deepen and endure. The India-UK corridor today possesses all the ingredients necessary to become one of the most defining commercial and legal partnerships of the coming decades. And such institutions such as ours have a shared responsibility in helping shaping that future. Honorable members of the dais, thank you once again for your gracious presence, and I thank everyone present in this hall. Thank you.
Thank you, sir, for your thoughtful closing remarks. You've closed the inaugural session in the most succinct manner, aptly reflecting the ideas and exchanges that have defined the engaging beginning. I would now request the speakers for the inaugural session to kindly allow us a joint commemorative ceremonial picture. Thank you, sirs. As we now move forward to the sessions ahead, which promises to deepen and build upon today's discussions, we take a short 10-minute break, a tea break, a brief pause to recharge, reflect, and perhaps continue a few of the conversations that this morning has so effectively sparked. We expect everybody to be back by 11:30 sharp. Thank you.
एक मिनट
वाले में प्रॉब्लम नहीं है। पानी एंड ये टॉफी रिप्लेस हो जाएगा।
Ladies and gentlemen, I request everybody to please be seated. We start soon. Ladies and gentlemen, we now move to the next session titled Building the India-UK Economic Corridor, the Role of Law, Institutions and India. It's my privilege to invite the discussants and moderator for the fireside chat to kindly take their seats on the stage. Yes, ma'am. Ladies and gentlemen, while we greatly look forward to the keynote address by Dr. Rajiv Mani, Secretary, Legislative Department, Ministry of Law and Justice, Government of India, in this session, I regret to share that he is unable to join the fireside chat today as he is assisting the Honorable Union Law Minister back home in India with some urgent last-minute commitments. Nevertheless, he extends his warm wishes to the ICA and remains committed to advancing the shared cause of strengthening and optimizing the role of ADR in unlocking the full potential of economic corridors in today's rapidly evolving world. The fireside conversation will now be moderated by Ms. Bhumika Indulya, founder and editor-in-chief of the Bar Bulletin, whose sharp editorial lens and engagement with the contemporary legal ecosystem makes her ideally placed to steer this conversation. We now turn to an engaging discussion with our distinguished panel, Ms. Geeta Luthra, Vice President, Indian Council of Arbitration and Senior Advocate, Supreme Court of India, and Ms. Katie Bayan. She's the Partner and National Head, Commercial Dispute Resolution at Irwin Mitchell LLP. Both speakers bring rich cross-jurisdictional experience across India and the United Kingdom, offering valuable and complementary perspectives on the evolving contours of the India-UK economic corridor. Without much ado, I now request Ms. Bhumika to take over and steer the session forward.
Thank you. Thank you so much. Am I audible? Yeah. Thank you so much, Akshata, for the kind introduction. And this fireside chat is going to be literally fires. There's going to be some fireworks in it. We have been talking about arbitration from quite some time, and so many arbitration weeks are happening. But I think we are not talking about the problems, the real problems. And I'm going to explore from Katie and Geeta ma'am the real problems and the actual solutions. I know the inaugural was really, really fantastic. And let's see what we can explore from this session. And I just request both of them to be really, really honest in this conversation. This is not a panel discussion. This is a fireside chat. Let's begin. So when we usually discuss about India-UK economic corridor, the conversation is always about trade, investment, geopolitics. But the deeper question is basically trust. Whether the jurisdictions are trusting the legal systems of India. Whether our legal system is able or capable enough to repose that trust. So if the confidence in those systems is lacking, everything else becomes harder. So let me begin with here that, Geeta ma'am, my first question to you is that India wants to become global dispute resolution system, destination. But don't you think our first priority should be attracting international disputes, or it should be fixing our domestic enforcement issues and dispute resolution first?
So this can't be an either-or question. It has to be obviously both at the same time. So domestically, we have to ensure enforcement. You have to make sure that when the courts get extension of time applications under 29A, they are happy to consider that, because that's not something which is so in-depth, even though Rohan Builders gave a paragraph which said, you know, it's not that you can extend at the drop of a hat, but the ethos in India seems to be, let's extend. You look for some reasons, however mild, and extend. Now, I don't think that's the way to go. We cannot and should not be extending absolutely, except for a small caveat or window where we don't extend. So this is one aspect. Second, when it comes to appointments, we are quick, say 11 applications. But are we as quick when an award comes and you have to look under 34 or 37? That's where the courts, particularly where it's a heavy matter, may be pushing the brief away. And that, I believe, is fatal. So having said that, I don't subscribe to a view that should we first look at fixing enforceability and then look at attracting people or the international sphere. And does India have confidence? So my first question is, we both have to have confidence in each other's systems. It can't be the UK having confidence in us, because I have to also repose confidence in them. So it's a two-way system, and I think that the way would have to be that perhaps we start looking at a common pool of international arbitrators. We start looking at judgments which are anonymized so that we have precedent. We start looking at committees which review what the arbitrator has done. And obviously, who will judge the judges? So you have to have very impartial, across the globe committees, international arbitrators who can do this review dispassionately. So there are many things which we need to fix, but the fixing has to be at both the domestic and the international front. And this issue, there are some very uncomfortable questions that will arise. Get a pool of arbitrators. Nobody is going to be happy about that. It will exclude many people and include others which you may not want.
Right.
But ultimately, you have to begin somewhere where trust and confidence is there in the arbitrator. That's the beginning point.
I think it's high time that we need to take some hard decisions. 2 days back, I was in a conference where Justice Chandrachud was speaking, and he said, arbitration is doing good, but it is short of destination. And probably we have been saying the same thing from quite some time. We are not reaching to our destination, what we want, because we speak at various events, we talk about it, but are we implementing all the suggestions which have been given? Thank you so much, ma'am, for putting this very nicely. Coming to you, Katie, when international businesses evaluate a market, how much weight is actually given to a dispute resolution and enforcement? And is it genuinely deciding a factor in investment decisions?
Thank you. I I think more and more dispute resolution is absolutely key to the decision of where to make a capital investment or where to trade. I think you only have to look at what's been going on with the geopolitical to see that where you place your business is going to impact on supply chains, on trade, on the world economy. So it's so important that there's a base of predictability, of certainty in the rule of law, and where you have that certainty and predictability and strong roots, then trade will follow, because that is what is so important. That's what clients will be saying to us as lawyers here is, if I have an award, where can that be enforced? Where is there some degree of certainty in the structure and the infrastructure of the government and in the rule of law?
Thank you so much, Katie. Katie, do you think you can see there's some trust in Indian legal system?
Thank you. Yes, absolutely. I mean, as we discussed today, earlier on in the inaugural speech, with some of the distinguished speakers we heard from, that the relationship and the existing history that we have between the two countries means there's a lot of commonality in the way we approach and the way our legal systems are structured, such that there is that trust already. And we've also referred to today the recent trade agreement, and I think that's fundamental to the fact that trade between the countries is only going to increase. The legal system being a trade that can also benefit from that, as was also mentioned today. So absolutely, I think there is that trust there, or certainly the basis for that trust, that there's no reason why we couldn't move towards seeing India as a centre for arbitration.
Thank you so much, Katie. Geeta ma'am, moving towards to another criticism which we have been hearing from quite some time, that Indian courts are interfering too much in the arbitral awards. Today, some argue courts sometimes differ too much in the name of arbitral autonomy, and while others say intervention remains unpredictable. So, has India found the right balance?
I think we are still finding our balance. So the initial reaction in 1996 with the new act was, let's not interfere. So however glaring was the problem, we thought, let's not interfere. And then slowly you made steps towards saying, no, where something's glaring, you will interfere. And the issues are very short, very small, but you can bring pretty much a lot of points in interference under 34. So have we found the balance? I don't think we found the balance. I think to a large extent, the balance will come when you have arbitrators who you feel and case management protocols which are extremely good. If you have arbitrators which are extremely good, I mean, I heard one person saying, award is as good as the person or the arbitrator making it, but we can't afford to have that personal decision making that is an award as good as the person making it. No, it has to be more predictive. It has to be more clear. It has to be more enforceable. So if there is an issue about the person making the award or the arbitrators making an award, then that's what we have to redress so that interference reduces. If it's something glaring, you will interfere. That's what the courts have to do. But it should not be glaring in
They are finding
many
everything
cases.
glaring. They are finding everything glaring, and probably we are forgetting that when we say arbitration, it has confidentiality. but half of the awards, like at least 80% of the awards are being challenged under Section 34. So where is the confidentiality over there? They become the public record. So I think everything cannot be a glaring issue.
Yes, yes, you're right. So confidentiality does go slightly out of the window. Now, obviously, you can have confidential clubs, you can have various methods by which you can maintain confidentiality to a large extent. But I feel there are two aspects which need to be looked. One is transparency, one is confidentiality. So transparency may come in the face of confidentiality, but transparency also ensures impartiality, whereas confidentiality may, in a sense, make the arbitrator more insular. So I think you have to anonymize judgments, and of course 34-stage problem will still continue, but if you anonymize to a large and have a good arbitration precedent library, then I think you actually would and make scrutiny more important, not scrutiny through the court, pre-award scrutiny, scrutiny of the arbitrators as an overall arbitrator. Is this person someone that you want to return to appoint as an arbitrator? And then comes the issue, with all this, do you want things like diversity? And I, for one, believe, and this Justice Nagaratna said in an ICA conference, she said, look, I think 1 out of 3 arbitrators should be women, but where do you bring it in? In India, you bought it in the bar associations, courtesy Justice Suryakant. You bought it in the Supreme Court Bar Association. You bought it in the bar councils. Albeit something where the court has been really over-pragmatic and over-progressive in a field where it was iffy if the court could look at it. But where it really matters, if you want to have diversity and a pool of good arbitrators, not that you put everyone on the panel who applies. So it's a very difficult...
I think appointment is another challenge, and we'll touch on that topic as well. Moving to you, from a client perspective, what matters more today? Cost, delay, or unpredictability?
Thank you. And just picking up on what Geeta was saying there as well, I think these are global issues, right, aren't they, in terms of appointing an arbitrator? This is across the board. That balance between transparency and confidentiality is so important. But going back to your question, Bhumika, so look, I think, all 3 of those elements are obviously key to any client when they're looking at some form of dispute resolution service. And in an ideal world for a client, they wouldn't have to encounter any of those. But I think there's common ground across most dispute resolution processes that cost and unfortunately delay will be factors. Clients don't want that, clearly, but, particularly, for example, in the UK now, litigation and arbitration are ridiculously expensive. Arbitration even more so, actually, and it used to be that arbitration was the cheaper option, and I think that's no longer the case. Delay, similarly, in the court system here, we've got tens of thousands of cases waiting to be heard. We have delay, and, the onset of AI and things are only actually increasing that. And I think we may come across that a little bit later on today, but if the court system doesn't catch up with that, as was spoken about by Sir Geoffrey Voss earlier, then that delay will continue. So to answer your question, I think it's the third issue, the unpredictability, which is the issue that can change, because there's a anticipation from clients that delay and cost to a large degree will always exist. But if they can get more certainty, then that will be a deciding factor.
Kitty, arbitration was supposed to be a very quicker thing, but it is also being labeled as too expensive. What is your thought on it?
You're absolutely right. I think it's interesting. So, from my perspective, sort of 10 years ago, you would see more and more clients wanting to arbitrate, and now I think, particularly in the UK, it's not so clear cut because arbitration now is very expensive. And gone are the days when you could say to a client, it will be quicker and cheaper. More often than not, it's not. So it's a difficult balance, I think, in that respect. And again, I think, we're all living in a world now where there's so much data around and there's so much evidence and all of that, and we all know as lawyers why matters become so entrenched and so expensive. And I think the key, if it's possible, will be to find a dispute resolution system that can try and eradicate some of that cost, if that's possible. It's the million-dollar question, because everybody in this room and every jurisdiction around the world will be trying to find a way where they can get a dispute resolution process that is, strong, reputable, trusted, but also cheaper and without the delay, and that's difficult.
Right. Ma'am, do you think arbitration is, because it's being said that arbitration is failing, that's why mediation had to come in picture?
I actually agree with you. See, arbitration is enforceable. Mediation, ultimately you can, if parties agree, of course it's enforceable, but if parties don't agree, it's clearly there's nothing to enforce. So mediation has probably come in because arbitration is so expensive. And that is why it's very difficult to take arbitrators to mediation. You will have a whole new subsect of people who are ready to be mediators. So this whole thing of arbitrator, mediation, arbitration, because arbitration is so expensive, mediation has become this more reasonable remedy. So in India, I believe, arbitration was always more expensive than litigation. But because it was the quicker remedy, you looked at your pros and cons.
It is not quicker anymore.
It can be quicker. It can be quicker,
It is not quicker, ma'am. It has become more, it is just a layer to reach to the court now. We have just added one more layer. And let's speak truth.
I think with a good arbitrator, and I've had arbitrations, very heavy infrastructure arbitrations, decided within 3 months. And there's no point naming those arbitrators, but I always feel so happy whenever they are named, because you know that it's going to be decided in 3-6 months, even with a witness or without a witness, mostly with witnesses. So there can be quick remedies, and those arbitrations have been so watertight that I don't think the challenge withstood. So a lot of it, so don't say all arbitrations. We can't say all arbitrations are like. We can say a
99.9%.
No, but a lot of arbitration like that. So I feel perhaps mediation's the way, but then you need very good, very trained mediators. I've seen mediators, because they want to get a positive result, they see who's the weaker party and start pressing on that person. Now that's not mediation. Mediation has to give both a level playing field, but definitely mediation's much cheaper. And I think in the course of arbitration, if you try mediation, it's better than a standalone mediation. That's my view.
Right. Ma'am, we also touched the topic of appointment of arbitrators, and I think you also mentioned that it is only, the appointment is happening only among the small pool of arbitrators. How can we fix this issue? what can we do? How can ICA, institution like ICA, should have done to increase the pool? Because then that is the only solution.
So, coming to ICA or any arbitral institution, the first thing is we have such a minuscule amount of the arbitrations in India. So institutional arbitration, so make arbitration real. In India, you have to have institutional arbitration. How do you persuade the parties, the judges, those who appoint the arbitrators to not go for ad hoc and go for institutional arbitration? One, you'll keep the fees at a cap, even though there is a cap under the Act. The moment you have institutional arbitration, you'll ensure a cap. But the point you are making is really the fire side of it. And that's the uncomfortable truth. Is the elephant in the room. How, even though we have a huge pool, the ethos of getting only retired judges, and time after time, particularly in high-stake matters, is not necessarily the right ethos. Make some lawyers sit, make some international lawyers sit, make some international arbitrators sit. You're going to improve quality because ultimately because of a slight reduction of transparency in arbitration, if you give that base of excellent arbitrators, and therefore, if I have a pool of 100 arbitrators in ICA, maybe, and I shouldn't have to justify it, if I start picking only 50 of them. I would say, give diversity, give gender, do all that. But at the same time, at least till you have a committee, do a internal assessment of your arbitrator.
But arbitral institutions then come up with this thought that it's the parties, it's their consent, it's them who choose the arbitrators. What they can do in order to convince the parties that you need to have a variety of arbitrators.
You can't do anything to convince them. First, you talk about party autonomy. So all you can do is, on your board, at least have excellent arbitrators. But for the parties, you can't really, some of them may actually ask for suggestions, most will not. They're all into arbitration, litigation in a big way. They already know who they want as counsels, who they want as arbitrators, and whether both parties agree or disagree or choose to disagree. But I feel that if somebody is impeccable, excellent reputation, excellent awards, parties may actually want to go for that person as long as it's transparent that this person's doing such an excellent job.
Is it happening, or parties are choosing where they can have some connects?
That's the other elephant in the room. but of course, a lot of parties, particularly business clients, will want an assured thing. So this is something we need to continue to keep addressing. See, it's only lawyers and arbitral institutions that can try and put this in place.
Ma'am, we have been addressing from quite some time now, and still arbitration still sits at the same place. The same question have been asked, the same discussion have been asked 4 years back also. The solution, okay, Katie, I want to ask you one thing. Do you think publication of awards will bring more transparency after redacting maybe of the confidential information? Do you think arbitral institutions should adapt this?
I think there's definitely benefit in that, but as long as we ensure that confidentiality is preserved, because clearly that's one of the key drivers that leads parties towards arbitration. I can see benefit in that. I think because not only then you start to get the precedent bank that we talked about, you start to see that there's some real depth and strength in the decisions and the awards that we made. So yeah, I think as long as that balance is maintained, which is a difficult one, but that transparency against confidentiality is maintained, then yeah, I think I see no reason why they couldn't be published with the appropriate redactions such that parties can't be identified, which isn't always easy.
Katie, if India could borrow 3 dispute resolution practices from the UK tomorrow, what would it be what are those 3 things which will make biggest difference?
That's interesting. I think, because I think, in the discussions today, this isn't necessarily about one jurisdiction being better than another or anything like that. I think, obviously, in London we've got, and in the UK we've got the heritage of such a trusted jurisdiction which sits behind us, but that's not something necessarily that can sort of be created overnight. And from what we were talking about today, clearly India has a very strong jurisdiction as well. I think there are some more sort of evolving issues that we can look at. AI, for example. Sir Geoffrey Voss mentioned it earlier. The courts are looking to have sort of some regulation around that, but AI is moving faster than perhaps we are catching up with it. So there are some issues there in terms of maintaining that and managing that, how AI is used properly and appropriately. Things like third-party funding, that's something, again, it is not quite yet, we've got very light regulation in the UK, but it is looking like it's going to be more regulated. That does provide access for justice, that does provide risk sharing, it does mean that lawyers have more of a vested interest in the outcome of a dispute, albeit that has to be married with conflict of interest. So there are a couple of those sort of practices, I think. I think fundamentally all of us as lawyers have a responsibility to ensure that we are looking to resolve the disputes, the best interest of our clients, not necessarily antagonize. Traditionally litigation, it's what we all know, it's very, very expensive, but ultimately the clients don't really want to be there, so resolution has to be key rather than litigation, and I think as lawyers it's all incumbent on us to make sure that we're putting that forward and we're absolutely promoting the resolution of a dispute, not the dispute itself. So there are a number of things, but I don't think there's any clear things that we're doing any differently necessarily to what's going on in India. I think, we do have the advantage of being a little bit more established and having that history, but absolutely, India can learn from that and can evolve and can adopt some of the new processes that we're struggling with, such as AI and third-party funding, but in a more modern way.
Right. Thank you so much, Katie. Ma'am, yesterday we have released draft AI regulations, and we also have few judgments, especially the Delhi High Court judgment on third-party funding. Katie has specifically pointed out to those. Yes. So would you like to, we have already been incorporating these best practices.
See, not really. Even though tomorrow's judgment is it's a very limited judgment. And I believe the UK has recently come with a slightly less inclusive judgment on damages. That in fact is perhaps less inclusive than its earlier practices, where third-party funding, if it is damages related, then the court would interpret it in a different way. But there are 2-3 aspects which is, a takeaway, which would be one, of course, third-party funding. The second, which you referred to, was AI. And though we have several judgments, we have P.V. Anwar, we have Arjun Pandit Rao, but I think those judgments are not sufficient to take care of various aspects of electronic evidence. I think we need in India a more wholesome judgment with the advancement of technology. What is there is that in arbitration also you'll have to do disclosures if the arbitrator wants on what tools you have relied upon, and of course have proper verification. Same thing that you would have in litigation.
The comments are being sought till 20th June. If you can state what is your thought on the draft regulations?
So I think it's much lesser than what may be internationally recognized, and I think the draft comments will go further. What is good is it says it can't do prediction, it can't do, lawyers can be asked what will be their AI source, whether they can say, make sure that there are no hallucinations, there is no wrong citation, because Justice Nagaratna's bench recently had this, then I think Justice Vikram Nath's bench has it. One of them even imposed cause or issued notice, because we'll have to be careful to train our youngsters. We shouldn't train them only that, okay, AI is an easy source. We have to train them in thinking and then to apply the use. It's a reality. I can't close my eyes to it. However much I may be in the old school, I have to keep my eyes open and we have to look at it. I thought in addition to third party, I mean, we've been talking of emergency arbitration forever. Now the UK has got a new act. The CAC's got new rules. So by the time we catch up, there is already something more to catch up. So we have to do another lot of catching up is all I can say.
Thank you so much, ma'am. My last question to both of you, because of the time constraint. If you could implement one reform tomorrow that would have the greatest impact on investor confidence in India, what would that be?
Is the first question, first answer. So, if I have to improve investor confidence, clearly it has to be enforceability. I can't be sitting with an award and then having people raise issues. So, fortunately, this issue that the Reserve Bank will be another, getting permission to repatriate the funds was one more tier. That tier has gone by a recent judgment of the Supreme Court. There were various aspects, in fact, in 25 and in 2026, which have come to improve enforceability, including what the Supreme Court has said, let's improve enforceability, let's make it enforceable. The real problem of a person comes when he has a decree or an award in his favor and not in getting that award. Now that's still real. And I think once an investor feels that he'll really be able to get his money, take it out of India if he decides, then all of us will have to sit up and realize that business is business.
Thank you so much, ma'am. Kitty, what's your thought on it?
Absolutely agree with Geeta that enforceability is key, but also resilience in the system, such that as the regulations change and as things become easier to make sure that an award is certain and less subject to challenge, that the resilience in that system is retained, such that it's not going to change again quickly. But yeah, absolutely, if an investor, if businesses realise that the awards that they're given are enforceable, then absolutely that creates the certainty and the predictability that takes us back to the conversation we had at the outset, where we said unpredictability was the real issue.
Thank you so much, both of you. Thank you so much for giving your time. India does not need to convince the world that it is an important market. It is. It is just the challenge is convincing the world that they can trust us. And I think the conversations are important, and I'm thanks to ICA for organizing such a beautiful conference where we are talking our mind. We are not restricted by saying that arbitration needs a major reform. Thank you so much, both of you, for speaking your mind. It was a great conversation.
Can I just say, IBA is giving a 40% discount this time to Indians in the IBA conference in Copenhagen. So I hope you people utilize it.
That was indeed a highly engaging and intellectually stimulating start to the day. It has set a strong tone for the discussions ahead. On behalf of all of us, I extend our sincere gratitude to our distinguished panelists for their valuable insights and perspectives. Can we have a group picture, commemorative picture for the panel? Thank you so much. As we draw this session to a close, I would request the speakers on the dais to kindly take seats in the audience. We will now take a brief 5-minute pause to regroup and reflect as we gently pass the baton to the next session. I request all attendees to kindly remain seated as we prepare to commence the next technical session soon. As we now move to the first technical session of the day on Beyond Silos, Architecting Hybrid ADR Ecosystems for Complex Commercial Indo-UK Disputes, it is my privilege to invite the moderator and speaker for the session, Dr. Pinky Anand, Senior Advocate, former Additional Solicitor General of India, and Judge at the Bahrain International Commercial Court, a distinguished jurist and an internationally acclaimed arbitrator whose experience at the intersection of advocacy and adjudication brings a truly global perspective to dispute resolution. I request all the delegates to kindly get seated and the speakers for the session to kindly join us on the stage, please. As we move to the first technical session of the day, can I request everybody to please be seated? As we move to the first technical session of the day on Beyond Silos, Architecting Hybrid ADR Ecosystems for Complex Commercial Indo-UK Disputes, it's my privilege to invite the moderator and speaker for this session, Dr. Pinky Anand, Senior Advocate, former Additional Solicitor General of India, and Judge at the Bahrain International Commercial Court, a distinguished jurist and an internationally acclaimed arbitrator whose experience at the intersection of advocacy and adjudication brings a truly global perspective to dispute resolution. We welcome you, ma'am. We are also joined by a distinguished panel of experts from India and the United Kingdom, each bringing deep and diverse experience to this evolving conversation. For the Indian perspective, we have with us Mr. Divyam Agarwal. He's the dispute practice partner at GSA Advocates and Solicitors India. He brings extensive experience in complex commercial arbitration and litigation. Mr. Sapan Gupta is Global General Counsel at ArcelorMittal, based in London, bringing a strong in-house and global industry perspective on cross-border disputes and risk management. From the United Kingdom, we're joined by Mr. Alexander Gunning Casey. He's a barrister at 1 Essex Court, UK, and a leading practitioner in international commercial arbitration and complex disputes resolution. Mr. Chris Paulson is partner and head of dispute advisory practice at PricewaterhouseCoopers LLP UK, with deep expertise in dispute strategy, risk advisory, and complex commercial resolution. Together, they bring a powerful blend of advocacy, adjudication, in-house leadership, and advisory experience, ideally placed to unpack the evolving architecture of hybrid ADR systems in the Indo-UK commercial disputes. I now request Dr. Pinky Anand to kindly take over and steer the conversation forward.
So, ladies and gentlemen, we have a continuation of a process of huge discussion. I think Bhumika, Ms. Luthra, and Katie led a nice panel here with very dynamic questions and at times damaging questions. But here we are with the world of ADR and the world of hybrids. As my portion here, we'll be discussing Beyond Silos, Architecting Hybrid ADR Ecosystems for Complex Commercial Indo-UK Disputes. I think we've taken over a number of areas about arbitration, about auditing, about neutrality, about autonomy, and the Chief Justice and Sir Geoffrey Voss spoke about artificial intelligence, and so did Katie. And Ms. Luthra was addressing some questions to Bhumika about Section 34, etc. But really, I think the bottom line of every conversation is arbitration as the world is, and ADR as the world is also an evolving field, and we are constantly evolving. We need to have the best. How do we reach in that direction? And I think as commercial dispute adjudicators, as we might call ourselves in that category, we are constantly looking for solutions, and we find them. I don't think there's a one shoe that fits all, and I don't think there is any limitation to what can happen. So what we are doing, for example, in our current situations when we handle positions, is try the combinations of what works. India and UK are heading for a very big relationship in terms of commerce. London is the legal capital of the world, as it is understood. India is bridging towards its own capitalism there. But we look for these solutions, and we have to, there are a couple of things I need to say here. And then we'll take some questions from our dear colleagues who lead the field in this direction. So two things that we need to pay attention to. Cultural identification, cultural values, we vary. I was just looking at some figures. So Britain, for example, in mediation had a success of almost 87%, whereas India, in comparison, had a success of 20%. And there are reports of SIDRA, there is a report of LCAM, there are various surveys that have really looked at this entire process. And one thing again which emerges very clearly is that there has been a hike of percentage of consideration of hybrids. As mediation within arbitration is something that we are all looking at. So it's gone from somewhere like 34% to 59% in the course of about 10 years. The last report, of course, was not absolutely recent, but that's the way it is. Beyond that, what are we looking at? Cultural, I was saying. So for example, in India, I'll just share with you. So people do not have necessarily a contract which emerges as a contractual relationship. There are various parts done, whether by exchange of WhatsApp, whether by exchange of messages or oral communications. Britishers, on the other hand, would actually narrow down their commercial relationships. For example, extension. It would be down on paper. It would be down as a commercially sound proposition, and therefore, that is the position. Again, Britishers, for example, would be looking at risk and evaluating risk at the outset. We as Indians tend to do that later. We start the war, and then we say, all right, we'll see what happens down the line, and then we'll take it there. So that's why, in fact, you'll find the UK Supreme Court has 30 cases in a year. India has 60 cases in a day in the Supreme Court. That's a kind of broad proportion. And nonetheless, I think we have to find a solution only for effective adjudication of sorts. So therefore, what are the samples that we have? We have arbitration mediation, we have mediation arbitration, we have mediation conciliation, conciliation being more active, mediation being more passive. We have a combination where, in fact, recently in arbitration that I was doing, we were actually doing the arbitration, and it had gone pretty much the last way on. But we were able to persuade the parties to mediate, of course, a commercial dispute. People want to carry on with their work. They want to have the money in their pockets, and even if they lose out. So the persuasion was, okay, guys, if you can't really resolve it, obviously 0 and 100%, then take a mid-level range and kind of call it quits, so to say. So that kind of broad solution that you follow. What I find and I advocate personally is even more mediation, arbitration, mediation, arbitration. Starting with mediation at the first outset, voluntary, arbitration, and when the award is reserved, to look possibly for a mandatory mediation, which forces the party, by that time they know everything what's happened. So all right, guys, do you want to consider your options now? And if that is successful, then to, of course, have an award, which ultimately knits up the whole thing into a consent award for enforceability. I mean, that's a clear distinction between the various options. Much has been discussed on pricing, cost efficiency, challenges, tier systems in India and otherwise. And believe me, we are struggling against all those odds to ensure that what turned out to be an option as an option to litigation which was not as effective, we should start changing gears. So that's a process. We are all sitting in the ICA 4th conference in London to try to change gears and to find solutions. But as Katie said about AI, similarly about solutions, the solutions cannot be there today. They'll be keeping on changing. So we'll keep discussing. We'll keep coming up with something as long as we can give people what they need and a dispute resolution. Two interesting models I want to share with you. There's something called Medalloa, which is, in fact, when parties come up with solutions, and they actually, this is more in sports, in salary disputes, in other such forums, and they give these two, they make a kind of finality to it, give it to the arbitrator, and the arbitrator has to pick up one option. It's not that they can actually decide midway, but take the best out of the two and try to come to a resolution there. It has been proving to be very effective in some professional areas, as I said, salary disputes and sports, etc. The other is an arrangement between protocols. So, for example, Singapore and China, Schengen, they entered into a resolution whereby the mediation is done at the SIMC, which in fact, incidentally, I've also done the SIMC, so I'm also an accredited mediator. But it goes from there. But when the mediation has been enforced, it goes to Shenzhen, where it becomes an enforceable award. That is the key word between the two different areas of mediation, oblique conciliation, and finally arbitration, because arbitration is more enforceable. The Singapore Convention has its own lags, the other one doesn't. Anyway, I'm sure that we can find more time to discuss this, but I will now head back to my seat and try to get my dear colleagues, who are some of the most outstanding people in the field, to be able to address some questions, and I'm sure I won't be as difficult as Bhumika was. So, Divyam, if I may start with you. You've seen the evolution of dispute resolution in India across forums, from commercial courts to district level courts. By the way, arbitration in India even goes to district courts, depending on pecuniary jurisdiction, and to high stakes international arbitration. In what areas has India genuinely improved procedurally, and where does it still feel the need to effectively deal with established jurisdictions such as London, Singapore, Dubai?
Thank you. A very, very good afternoon to all of you. It's a privilege to address this August gathering. I'm grateful to ICA for it. Dr. Anand, to address your question, let me divide it into three parts. The first part being where we are. Second part is what has worked for us. And third part is what has not worked, how should we improve upon it. So for where we are, this is easy. Let me give you some statistical points for it. Queen Mary University did a survey last year in collaboration with White & Case. In that survey, India, the only city of India that was ranked as an arbitration hub was New Delhi, and it was at 20th position. 2% of the people subscribed in that survey and declared that New Delhi is also to be considered an arbitration hub. And let's compare it with the fact that number one was London at 34%, followed by Singapore at around 31%, followed by Hong Kong at 31%, and thereafter followed by Beijing at 24%. While it's a stark number that we are talking about New Delhi as the only city in the arbitration hub, and it's somewhat only at 2% as opposed to 34-31%. But cut to 2021, the earlier survey which Queen Mary and White & Case conducted, that survey, India had no place. So, of course, there has been an improvement. I would say it's more of an incremental improvement rather than transformation. So that's where we are. What has worked for us? Let's look at a couple of points that has worked for us. Point number one is the judicial attitude. That has really, really improved. We heard the Chief Justice of India in the morning. He was talking and praising about how important the relationship is India-UK and how arbitration plays as a catalyst in that relationship. Apart from that, I was fortunate to participate in a discussion that happened a couple of days back, which was a commercial litigators forum. CLF organized a meeting between India and UK practitioners, and this was followed by a CIFOC committee meeting, which is a standing institution for commercial court. What is relevant to note is that 4 sitting judges of Delhi High Court was present for the meeting virtually, and the meeting was presided over by Justice Robin Knowles, who's a judge here in High Court judge in England and Wales. The discussion, the entire theme was that how arbitration plays an important role, how we can improve cross-border disputes, how mediation can have a tie-up with arbitration, and how that hybrid approach can work. And of course, AI was also a recurring theme. So coming back, judicial attitude has changed over a period of time. I remember the day when we used to appear in commercial courts in India, or for that matter, High Court in India, and when we used to press for a hearing of an arbitration matter, and the reaction of a judge was, it's a commercial matter, it's about money, why are you so stressing about it? We have more important things to do. versus Chief Justice of India making a statement today that in arbitration, the courts are like co-partners. So that's the distance we have traveled. So judicial attitude has improved. Second is institutionalization of arbitration. Again, India has historically been an ad hoc favored dispute mechanism. There still continues to be a majority of arbitration conducted through ad hoc mechanism. But institution in the last 5 years have seen a stupendous growth. ICA is one of the leading institutes in India conducting arbitration on a regular basis. You have the Mumbai Forum, you have the Delhi International Arbitration Center. Various forums have come up. Every city has now its own international arbitration center, which goes on to show that we have, in a way, accepted institutional arbitration. And more importantly, institutional arbitration is relevant because it gives a structured mechanism to conduct the arbitration. There is a process, there are the rules, it's in a more defined manner, and it allows parties to actually resolve disputes in a more procedurally effective way. Point number 3 is the stakeholders like corporates, the stakeholders like the service takers, the clients. They have attained that knowledge about arbitration. Earlier, when we used to advise the client and suggest that let's go for arbitration instead of court proceedings, there was a hesitance, there was a reaction. Now, in fact, in complex dispute, arbitration is the favored mechanism. While, of course, we have, and I will deal with that fact, the issues which have been faced, but I don't agree that arbitration is not working. It is working, and it is working really well. Complex disputes in India cannot be resolved through court. It has to be resolved through arbitration. Courts do not have time to go through extensive expert reports, go through hot tubbing, go through any kind of a detailed arguments. So arbitration is there, arbitration is going to continue. So these are the things that have worked. And let me address the last point on what is not working. Let's also face the reality. I'm not here to sugarcoat things and just suggest that arbitration has worked very well. The difficulty, I would say, what we have faced is, one is, of course, the mixed administrative signals what we have received. While it's good to speak in these forums, talk about it, having dignitaries coming across the globe, and we keep thumping our chest that India is really doing well. But then the stark reality is there is an office memorandum of May 2024, which is staring at our face. And while there have been instances where government, court have come forward and said that office memorandum doesn't mean anything, but go to the public sector authorities and explain to them, because they have already started adopting and changing their tender clauses. They have started adopting dispute resolution mechanism, which does not factor arbitration in. So yes, the thing that has not worked for us is a mixed administrative signal. We really need to improve. We really need to posture and provide a more focused approach and show that we really mean what we are saying. I mean, it looks like that we are saying that we should arbitrate and we should not arbitrate enough. So that kind of
that's good, Divyam. Actually, ladies and gentlemen, there has been this development on the administrative field. And indeed, believe me, everybody is fighting about it, because ultimately we do need to change. The circular itself prescribed that over 10 crores litigations or disputes would not go to arbitration, and that's proved to be quite a dampener in the process, but that's being ultimately contested, and hopefully with the revision as is being contemplated, that might be taken back. There have been reasons for it, but we'll go back again. But thank you, Divyam, for the honesty there. Chris,
thank you.
Coming to you, how do institutions such as the LCIA and SIAC presently approach hybrid ADR mechanisms, and what unique challenges or vulnerabilities arise when seeking to enforce outcomes emerging from hybrid processes such as MED-ARB or ARB-MED-ARB, or as I said it, MED-ARB-MED-ARB?
MED-ARB-MED-ARB. Thank you for the question, Dr. Anand, and good afternoon, everyone. The first part of that question was about London versus Singapore. Those two forums have very different approaches to hybrid ADR. London does not specifically provide in its rules for a hybrid approach, but Singapore does. And Singapore is fairly unique in that respect. Singapore has a specific set of rules that contemplate, if you want to go in that direction from the outset, a 8-week, I think it is, mediation process with a particular institution, which happens to sit just down the hall from the arbitration center, with completely different set of neutrals. And it's very well formulated, very well articulated, a well-worn path. London, by contrast, allows you to design a process like that if you so desire from the outset, but it does not specifically provide for a particular process or timelines under its own institutional rules. I'll also add, you may pick from my accent, that I'm from your Commonwealth cousin across the ocean, and Canada and the US have, I think it is still the largest bilateral trade relationship in the world, or at least it was until recent events, which we'll see. And hybrid ADR has actually become a more prevalent approach to cross-border disputes between those two countries as well, particularly in cases where, and I think we'll come to this later, issues of cost or speed are a significant consideration. A large part of the trade between those two countries is agricultural products or energy products, where you may not necessarily want to wait the 9 to 12 months or longer for a fulsome arbitration process to unfold.
I think everybody's very honest here. So Divyam came out with some of the setbacks in India, and Chris has very kindly been fair on the LCIA and the difference between SCIA, etc. But of course, Singapore actually has been leading the way. And I think that's really an interesting one to watch. They're the quickest to evolve. I think I have a little more affiliation by now, because SICC is also the appellate court for the BICC. I've just become a judge of the Bahrain International Commercial Court. And so one sees them constantly evolving. And the other one forum which is actually evolving, as I see it in the ADR field, is the Kuala Lumpur, the Malaysian center, which I believe is really doing AIAC, as it's called. And it's really tremendously evolving itself in all directions. But I don't want to go in all possible ones, because we've had some discussions earlier on the other subjects. So let me vary this back to Sapan now. Sapan, you are unique here. So you are a general counsel, unlike all of us who are out in the field in one way or the other. You take both the boardroom sequence as well as the outside sequence, so you have the advantage of both. But particularly in energy and infrastructure, the commercial relationships are often long-term, and the market is relatively concentrated, with a limited number of major participants repeatedly interacting across projects and jurisdictions. In that context, do you think hybrid ADR mechanisms offer particular advantages by allowing parties to preserve commercial relationships while still ensuring formal dispute resolution?
Thanks, Pinky, and I think the ICA, the Indian Council, is running on the Indian Standard Time. So apologies to the speaker following us and for all of you who had to wait this long for the panel. I think keeping the honesty theme of the panel so far, I think mediation has limited growth potential on the commercial side. I think that's what we believe, yes. Contract do have mediation clause, but most of the mediation, unless there is a government counterparty, are taken as days to be passed, like few weeks, which 60 days or 90 days that you will pass through it. And one of the main reasons for that is that integrity of interlocutors is a doubt. No party is willing to trust a mediator. And as it remains non-binding, it is very, very difficult to find someone where both parties are willing to put full trust on and follow the advice. But in many of the contracts which will continue, which is more pre-dispute, that if you are dealing with the same set of parties, same set of petrochemical companies, same mining companies, then the mediation works without calling it a mediation, because the individuals, say our procurement department and the sales department, have built a relationship over the years that they try to sort out the dispute or the disagreement among themselves without formally going into mediation. So in our contracts, we are writing that, okay, there will be a mediation period which will go into, if it fails, then it goes into arbitration. But invariably, the mediation is failing. In the commercial contracts, because everyone is ready to go for arbitration, So as a clause, we do see a future, but as an enforcement efficacy, we don't see much of a future in the commercial negotiations.
But Sapan, tell me, you're saying for enforceability, that's why the hybrid mechanism, as we are talking, that's why the preference for mediation with arbitration in one form or the other, whereby you result into a solution, but it is enforced through the medium of yet another system. So the collaboration is what you're really talking about. So why is that not effective? You do the mediation, as you said in your contracts. So why can't we have it enforced through the arbitration process, as most people are doing? I mean, that's the general experiment across.
So most of our clauses are structured in a way that the parties will try for mediation for 60 days, appoint a mediator. And then you spend half of the time appointing a mediator, and then you have one meeting. And that meeting is more that you go through the process, if there's a court-appointed mediator in many of our US cases. But the intention is that the offers are so apart when you sit down that it just doesn't lead to any settlement. And then you move on to arbitration. So yes, it is enforceable if parties agree, but neither of the parties are agreeable to make mediation binding. And the commercial differences are so huge that it's just like our external counsel saying, the court will not like it if you don't do the mediation. Unless you attend it, it will not send a good signal. And then we just go do the formality and move on. So that's how it really comes down to in the practical life.
So ladies and gentlemen, I'll just share a part here that there are some jurisdictions, including in India, whereby the process and the time undertaken in mediation is not really considered to be a part of the whole process. And sometimes if you try it simultaneously, which is yet another hybrid that we are all talking about, you start the process, appoint an arbitrator, keep it in abeyance, start the mediation, so that the whole process goes simultaneously and you are there on the table. But I mean, of course, Sapan has some internals to always take care of, and you would understand, but this is the reason that we are talking about the evolving world. So, Alexander, to come to you, there is a growing concern that overly elaborate multi-tier dispute resolutions can become procedural obstacles. Now that's what I think Sapan just brought up there. So we'll just take it from there, rather than facilitative mechanisms. Do you think layered pre-arbitration requirements risk undermining the very efficiency that ADR was intended to achieve?
In a word, I don't know if this is on.
No, it isn't.
It's not. Where can I use this one? Okay. Does this work? Yeah. In a word, yes. I do think that there is a danger with these overstructured mechanisms. I mean, I come to this slightly from the perspective that there are very few problems in life to which procedural formalities are the solution. And I think I look at these multi-tier arbitration clauses and I've seen them causing problems. I've seen them causing problems from both directions. So from the kind of claimant's perspective, I think there's a sort of famous American legal philosopher who said that everybody has a plan until you're punched in the face. And I think there's an element of that with disputes work. Disputes arise when there is conflict between the opposing parties, and often when conflict arises of that kind, you need immediate or prompt solutions, and it can be a source of concern if when you find yourself in that situation, you suddenly have to ask yourself, well, why are we having to go through this multi-tiered process? I can think myself of a case where I was instructed by the liquidators of a company, and we only got consent from the court to commence arbitration proceedings on the cusp of the limitation period for the claim. And needless to say, there was a multi-tier arbitration clause. We commenced the arbitration, and then we had to have a ding-dong with the other side about whether our failure to comply with the process went to the jurisdiction of the tribunal or not. It might be a topic we come back to, but generally they're thought not to. We got over it, but why have that problem? Looking at it from the other side, from the respondent's side, I think when you look at the way in which the English courts have tended to deal with these multi-tier arbitration clauses, they are concerned about the potential that they might have on the jurisdiction of the tribunal. And so they've tended to rationalize their approach to them by saying, well, the first part of it, the bit that says you've got to negotiate or mediate, is unenforceable. I mean, that's even been said in relation to the LCIA mediation scheme. And I think if you're on the respondent side and you want to mediate, you'd be pretty shocked if you found out that actually what you thought you'd agreed to this mediation process, and actually the court's telling you you haven't. So I do think there are problems with them. I think underlying those problems is that these mechanisms are most effective where they are kind of optional or permissive, where you give the parties the opportunity to use the option rather than forcing them to go through it as a kind of hoop, as Sapan was indicating. The moment you just set hoops, people don't take them seriously.
We see what you mean, well, Alexander, because ultimately what we are trying to do in this world today, the discussion really is how to maximize advantages and how to minimize issues. So that is where the ball is rolling. But I mean, overall mediation, for example, in India, when mediation was being introduced in the Act of 2023, there's a huge debate about whether it should be voluntary or it should be mandatory. And we look at the Italian and the other clauses, and we were considering the opt-in model, but finally we came back to the voluntary one. So you're right there that if you start having a dispute or discussion by the courts or adjudication, that will be yet another tier. So that creates what you don't want to create. So the hydra-headed monster is also something we need to fear and to evolve out of it.
I mean, I think that's this whole question of whether you can order people to mediate was a topic that people wrestled with in England in the early stages of mediation coming in and being encouraged through the civil procedure rules. I think there certainly is a case for enabling people to order people to mediate. It makes sense if at the first case management conference there's been no appropriate discussion that the court or tribunal should be able to direct that the parties mediate. It may be that I mean, the court or the tribunal in that situation can take a view about whether there's any point, because, you know, let's be honest, many defences are complete try-ons. Why on earth should you force a claimant with a lock-solid claim to mediate that claim? I mean, they should be able to proceed as quickly as they can to judgment and enforcement. But equally, you're going to have many cases which are, which are less certain, and it may make sense to mediate if the parties haven't done that before. But I do think that most sophisticated commercial enterprises, as Sapan was indicating, mediation is like just a formalized process of negotiation, which they're perfectly capable of doing with contractual counterparties with whom they want to maintain a long-standing relationship.
No, but then, again, Alexander, what you are saying is that mediation may be a negotiation. Call it what you like. Call it negotiation, call it conciliation, call it mediation. The point is you actually put across your surfaces and you're able to at least narrow down the possible area of disputes. I'm sure to some extent I understand that parties know it. But at the same time, if you can, sometimes a middle ground can be found. And that in a commercial and contractual relationship, particularly in today's world, in energy, infrastructure, construction, you need these things over and done with because you need to get on with things. So that I think is the ultimate direction that you look for. I mean, you want, if we have the simple legalistic kind of formulas, the silos, each independent and therefore clear-cut, I guess it has its own legal advantages. But practically, I wonder whether we don't really work better with the hybrid formulas, whether voluntary or mandatory. As I said, there's no one shoe fits all. You just have to experiment at it. But there have been times we've been very successful in some of the arbitrations we have done, ADRs that we have done, by mixing and merging. Clients also do tend to see a third party as somebody more persuasive than their own claims. Of course, they're competing and they'll fight till the heavens go down. But as a third-party intervention, you do tend to look upon it sometimes more rationally, whether it is a commercial matter and frankly whether it's a non-commercial matter. And that does tend to, if, for example, courts, in our country at least, the judges saying something for mediation works pretty well. I mean, even though we've seen people rise up and say, no, we're not interested. You have every kind of person, but you have these situations where you do have interventions coming in from the third party, courts, oblique ADRs, and that being effective. And ultimately, of course, then the question is engagement into enforcement. That's yet another chapter. Anyway, the solutions is what we are looking for. So Divyam, what do you think, has international arbitration become too litigation-like? And are we concerned with issues which were discussed earlier also in cost, delay, procedural complexity? In fact, I like one comment before you give your response, that there is so much complexity which is sitting around jurisdiction, it was said in the earlier session, that you're really deciding what is right, what is wrong, and then it takes a lot of time before you get on to the actual position in hand.
Yeah, just before that, on your mediation point, I think one aspect which we can further deliberate upon is the timing of it. While most of the discussion has been happening that we do it at the upfront, at the beginning of itself, that time the emotions are really charged. I think once the arbitration proceeding is underway, we are halfway through, parties have seen each other's pleadings, they know what the claims have been made out. That's the, and they have a bit of a arbitration fatigue starts setting in. Possibly that is a time when it works better than it works in the beginning itself. So that was just one short comment on that. On your aspect of whether it is litigation-like or not, frankly, if Rob Van Winkle sleeps in in court proceedings and he gets up in an arbitration proceeding, will he be able to make out a difference? Maybe after an hour or so, not before that. So yes, the things have become more complex. Now the arbitrations, there are lengthy evidence, there are delays which are crippling it. But we can really work around it. We can possibly have document-only arbitration. We have modes like fast-track arbitration, online arbitration. Those aspects are evolving right now. We are getting close to to this difficult task that we have been started arbitration, comparing it with court proceedings. If we want to avoid it, then possibly a hybrid mechanism is also a good solution.
Well, Rip Van Winkle has also come into the story, and I guess that the main attempt is to get Rip Van Winkle out of the way. That's a task that we lawyers are all looking for, and adjudicators. Chris, there are two significant developments in hybrid ADR in the Indo-UK context, and we are sitting there as part of this Indo-UK great conference that we are in. The India's Mediation Act of 23 and UK Arbitration Act 2025. In practice, how do you think these frameworks operate alongside each other in cross-border disputes? Do they work in a complementary manner, or do they create procedural and enforcement difficulties?
There's challenges. They are complementary at a high level insofar as they encourage party autonomy, but it's not a well-worn pathway at this point. There's differences in the scope of the issues they deal with. For instance, unfair prejudice or oppression remedies tend to be dealt with by the courts in India, whereas it's much more common in London for those to go through an arbitration route. There's differences in certainly case management, administrative aspects. There's differences in third-party funding elements. The devil is really in the details. And a good example of this would be, in order for a settlement agreement to be registered as a consent award in India, there are certain characteristics of that settlement agreement that need to be in place. And if the seat and the governing law of the arbitration clause were to be based in London, you may have a situation where the drafted settlement agreement does not become a binding arbitral award in India. And that could be just a matter of oversight. What is acceptable in one form is not acceptable in another. And I think that's just one example of different jurisdictional misalignments that still exist today that I'm sure in due course will be resolved, but we'll save that for the next conference maybe.
No, you're right, Chris. In fact, the Singapore Convention has its own headaches because of the enforceability aspect. That's why we did discuss that. And for example, under the Indian Mediation Act, international mediations are not enforceable. So there is a difficulty, and we have to constantly grapple with that, how to enforce, and therefore the consent award, which is the ADR hybrid that we're all talking about. Sapan, you are as I said, reflecting the users in the primary capacity, and you really have seen it all in the boardroom where it happens. Do you think that international arbitration is often criticized as becoming litigation without the courtroom?
It has definitely become much more expensive, but I would say international arbitration is a very broad term. It depends where you are. I think in UK it's still pretty good. In India it has still a lot to achieve, I would really say. In Brazil it's very well developed. In US it's very well developed. So there is no general brush that international arbitration is doing bad or good, but generally it's doing better, we would say. India, all of us know what the issues are. The judiciary needs to really enforce the awards, and there is a bit of an interference by the courts in the procedure itself. But we still rely a lot on international arbitration. We still rely a lot between two commercial parties, between commercial and state. And we have been able to enforce awards in many jurisdictions. In many, we still don't have been that successful. But arbitration still remains one of our preferred mode of disputes. And we avoid going to the courts if it's not absolutely necessary.
Thank God. Positive notes. So we come back to ADR standing up tall and high, particularly in arbitration for international arbitrations in your disputes. And you're right about the enforceability. That, in fact, is one of the maximum aspects on that. That's why people go in primarily for arbitration, and the hybrids are adapted around that because the enforceability is ultimately of the New York Convention and what follows thereafter. So that's the whole game which is ultimately going.
Yeah, but my worry, Pinky, is that when we keep on going back to mediation, when arbitration is probably takes some aspects of mediation, takes some aspects of litigation or disputes, why do we keep on bringing that mediation or hybrid and mediation can still be successful and not put all our energy in arbitration? It's not, the world has already moving or has moved towards arbitration as far as the commercial bar is concerned. So why don't we just focus on that and improve it instead of bringing on the question, which are probably settled?
Good point, Sapan. I mean, you're right. In that sense, the world has moved a lot towards arbitration. It's been a propelled move through the various countries and the international forums. I guess all I can understand from this is that what might be the problem is that arbitration is becoming also court-like. In the courtroom is a question that I asked you. And therefore, you want to head back into yet another direction which facilitates. So yes, we reform arbitration. If we can put in some part of mediation within that process, very well. But we don't have to do it. You're right. Nothing is have to. We are only experimenting with various formulas to see where we can go. And I do believe, actually, personally, I don't know specifically about the cases that you're talking about, but I do believe that mediation has an important role that it can play in commercial disputes. I mean, parties, as I said, in UK, we did find a high percentage of matters which were settled as far as disputes, commercial disputes are concerned. So, well, I mean, we go back and forth, but the whole idea of conferencing and the fourth conference of IC and the others is to actually just decide how to evolve ourselves as the best solution givers in this hybrid formula that we are trying to think of, because you do need it at times. But as I said, you could knit it in. You don't have to have it as a separate, as Alexander was saying, multi-layering itself can be a problem. So yes, you need not necessarily say that there will be multi-layering, have it optional. And in any case, most of us, I'm sure, who are sitting here as arbitrators, would actually go into these processes formally or informally. It's something that we do as a matter of course, because you're all there to try and finish the dispute, not to protract it. But I do have a lot of problems. So just let me share with you one recent one. As an arbitrator, the parties wanted to produce experts. And somebody spoke about discovery in the earlier panel. Now, if we put it all the regular CPCs, the civil procedures within arbitration, then we've had it, because we're going to put it down the route of yet another litigation. And that's something that we didn't want to do. We bought it for another reason. So we have to keep pulling back also in some fashion or the other, and to minimize as much of procedure that we can put into arbitration, to have it across the board and really, in one case I'm doing, there's been evidence going on forever. The parties wanted to lead evidence. Oral evidence in a commercial matter, actually absurd. But these are the problems. So another very interesting issue in this hybrid is of double hatting, Alexander. So you really have, should you have the same individual as mediator and arbitrator, even though Sapan is saying I shouldn't talk too much about mediation, but what the heck?
Well, I think there is a place for mediation in arbitration, for sure. And part of the reason that there's a place for mediation in arbitration is that there isn't much incentive on arbitrators to encourage people to mediate. I mean, arbitrators have a financial incentive in the case fighting to the end. And so it's quite good to have nudges that encourage them to go there. On the question of double hatting, should you act as both arbitrator and mediator? I think in the ordinary course of things, no. I don't think that's a good idea. I think mediation is most effective where confidential information is given to the mediator, where the mediator is able to explore and evaluate the arguments that they're given, where the mediator is able to push away at the relationship between the client and the solicitor with a view to say, are you really telling your client that this is the position? And that is a catastrophic situation to find yourself in if you're also going to arbitrate the dispute. So I believe that there are some areas of mediation in which that is not uncommon, even in the UK, so family mediation and stuff, but I think for commercial mediation it's a seriously bad idea, and I think the Singapore model of having a separate roster of mediators makes a hell of a lot more sense.
Yes. What do you think, Chris?
Yeah, I agree with Alexander on that point. And the Singapore system is working relatively well for a given band of disputes. I think someone on the prior panel characterized it really well by saying there's different dimensions of what you seek in your dispute resolution process, and without question, cost and time are expanding in the arbitration world, and that's becoming increasingly a problem. And I was on a panel recently where they didn't suggest mediation per se, but they said we really need to revisit the procedural orders and what are some case management solutions to help rein this in. But I think mediation in the right context is useful, particularly when cost for the parties is a consideration, and that, in my experience, means that the award is likely to fall somewhere in a band of £5 million to £30 million, somewhere in there. I think the parties are going to be amenable to a quicker resolution and more cost-effective resolution. But as with all things, it comes with the trade-off of the certainty of the enforceability of the award. So one has to become more compelling than the other at some point. And in my experience, that's kind of where the tipping point is.
So the last round of questions is a quick answer to what would each of you suggest as an at least near ideal clause as far as hybrid ADR is concerned, or ADR is concerned. Let me not confine it to hybrid. I know someone might have a difficulty there. So like in 30 seconds.
I would actually request external counsels to draft and then I can vet it. But I would simply say that on a low value contract, I think Chris made point that below, for a company of our size, I think below 50 million, I would encourage mediation, and beyond that, we will simply go for arbitration.
Clear cut, Sapan, thanks.
I think arbitration and then mediation usually works in that order for me.
Alexander?
I would say opt-in for mediation before arbitration, but then making sure the institutional rules for the arbitration empower the arbitrators to, or encourage the arbitrators to consider mediation at the first case management conference.
Chris?
I fully agree with Sapan. I think the context matters greatly here. It depends.
So the winner of today's debate is Sapan, I think. well, ladies and gentlemen, this has been a nice time. Thank you very much for sharing this with us. I know we've gone up and down, but the idea is to put it on the surface. It is not the end, it's the beginning of evolution. Thank you so much. Thank you, everybody.
We request the speakers to kindly come together for a commemorative picture. That was a deeply enriching and thought-provoking discussion, further building on the intellectual momentum of the day. On behalf of all of us, I extend our sincere thanks to our distinguished panelists for this insightful contributions. As we draw this session to a close, I request speakers in the dais to kindly take their seats in the audience. We now take a short 5-minute pass over as we smoothly transition to the next session of our program. I request all attendees to kindly remain seated as we move forward. Ladies and gentlemen, I request the speakers for the session to kindly take their seats on the dais, please. We now turn to the final session of the day on strengthening the India-UK economic corridor, role of ADR in cross-border trade and investment, which, after what has truly been an intellectual marathon so far, promises not just to conclude, but to catalyze further thought and discussion on the evolving role of ADR in strengthening cross-border trade and investment between India and the United Kingdom. It is my privilege to invite the moderator and speaker for the session, Ms. Karishma Vora, barrister and international arbitrator at 39 Essex Chambers, a distinguished practitioner with deep experience in international arbitration and complex cross-border disputes. We welcome you, ma'am. We are also joined by a distinguished panel of experts from India and the United Kingdom, each bringing rich and complementary perspectives to this closing discussion. From the From the Indian and global interplay side of the conversation, we have with us Mr. Nitesh Jain. He's partner in the dispute resolution practice at Trilegal India, with extensive experience in complex commercial disputes and arbitration. Mr. Abhijit Mukhopadhyay is President Legal and General Counsel at Hinduja Group. He's based in London, bringing a seasoned in-house and global corporate perspective on cross-border legal strategy and risk. Speaking for the United Kingdom perspective, we have with us Mr. Fraser Campbell-Casey. He's a barrister at Blackstone Chambers, UK, and a leading counsel in high-value international commercial and arbitration disputes. Ms. Amanda Clark is CEO of HKA and chair of DARB at RICS, UK, with extensive expertise in dispute resolution advisory, risk, and infrastructure-related claims. Together, they bring together an advocacy, education, in-house leadership, and advisory expertise, offering a well-rounded perspective to distill today's discussions into actionable insights for practice and policy. I now request Ms. Vora to kindly take over and steer this discussion forward.
Thank you, Akshita, and thank you to the Indian Council of Arbitration for always bringing together a great cohort of people, and to all of you for sticking to what I think we will all agree is the graveyard shift before lunch. We'll be brief. And in case we're overrunning, I will ring the glass to ensure that all of our speakers allow us to proceed to lunch quickly. So, we're here today to discuss on this particular panel, strengthening trade, investment, and commercial relationships. And yet, somehow, we have assembled a panel comprising almost entirely of people whose careers depend on those relationships going wrong. Business persons seem to be able to price risk. They seem to be struggling with pricing uncertainty. And so what I would hope that this panel gives us by the end of our session is some sort of certainty about the way forward. Starting with the Indian perspective, Nitesh, if I can call upon you, I think the biggest sort of elephant in the room as far as Indian disputes is concerned is the pendency of court cases. So how do you think that can be resolved?
Good afternoon, everyone. Thank you, Karishma. So, I mean, I was checking earlier today, and so in India we have the national sort of grid system, judicial grid, where you can see the pendency of cases live, right? There's a data, and it's updated sort of every day, right? India has around 50 to 55 million cases pending, right? While these are the numbers that show that how many cases are pending, but on a daily basis, there are thousands and lakhs of cases that are disposed of every day, right? And this, of course, excludes the arbitration and the quasi-judicial sort of cases that are ongoing in India. Courts are overburdened. There are delays. As far as arbitration is concerned, we have made significant progress over the last 10 years. There have been series of amendments in the arbitration basis, what's happening in India and outside. I mean, there are judicial developments, but sort of the government is very proactive in making those changes, right? But I think the change that has to happen in the resolution culture, so to say, right? It has to be something which is other than the court litigation and arbitration, which is where everyone is now pushing for mediation, right? I think that's the sort of quickest, the most efficient, cost-effective, practical way, I mean, in terms of business sort of the requirement, right? That's the best way to sort of resolve a dispute, right? 2023 is when the Mediation Act came in India. The idea is to sort of strengthen the resolution culture, to sort of make it more efficient. This is on the lines of the Singapore Convention. I mean, India is a signatory, but India can't ratify it till such time we have our own domestic legislation. That's why we had, right? The system is working very well. and just to sort of, I mean, I was hearing the earlier panel, right? The mediation is not to replace arbitration. These are two different things altogether, right? The idea is not to litigate. The idea is not to arbitrate, right? The idea is two business parties, they're sitting together, you have a mediator, if you're able to resolve it. Lawyers are kept outside the room. Of course, they're there to guide you. The idea is to sort of resolve it quickly. In the Indian context, mediation is not for the first time that it has come under the 2023 Act. It's been there under the Indian CPC, since 1908. Various high courts in India, they have their own mediation cell. The matters are referred by the courts to mediator that please go and try this mediation, and it is actually working. Delhi High Court has its own mediation cell. They have their live website. If you'll see, you will see data for last 10 years. They will explain to you 45,000 cases have been referred. These have been decided. These were unsuccessful. There is a proper sort of statistics that's working, right? So I think the way forward and how the world is moving, right? India has FTA with the UK, with EU, right? The trade's gonna increase by billions and billions, right? I think London will have sort of added advantage in the India-EU, the FTA, right? Because, London being sort of a neutral place, right? So all these things, I think, if you have to move fast, the most effective way is to think about ADR, is to think about process like mediation, where you think about changing the culture of sort of resolution.
Thank you, Nitish. So I think that it seems that we can take a leaf out of some other countries. For example, in Australia, a significant number of court cases were reduced by the introduction of mediation in the 90s. Fraser, just a quick comment from you. Is it possible, or do you think that it has already begun to reduce cases in the UK?
Thank you. Yes, I think very sadly, from a barrister's perspective, mediation does reduce cases going to court. I think the one point I'd make is there's been discussion earlier on, as there often is in arbitration, about do you want med, arb, med, do you want arb, med, med, do you want arb, arb, med, med, med. I think the thing to bear in mind, I think, is that mediation doesn't have to be just a one-off showpiece event where you have a mediation day and it either works or it doesn't. Mediation can be used as a tool on an ongoing basis throughout a process in parallel with litigation or with arbitration. It can go in fits and starts and eventually succeed, or it can partially succeed if it takes some issues off the table and reduces the scope of dispute. So that's something I often advise clients. Don't think of it necessarily as something which is tried and then either works or doesn't.
Thank you. So it doesn't have to resolve the entirety of the dispute. It can take a few issues out of the case and narrow the issues in the case. Thank you. Mr. Mukhopadhyay, coming back to you. You bring a very valuable industry opinion to this panel. And my question to you is, how does one preserve the commercial relationship amidst a dispute?
It's a million-dollar question. It is like I'm fighting with my wife, yet maintaining good relations. I really do not know how does it happen. This is such a vast subject. I think I need one day to complete my conversation. Let me tell you like this. We are a commercial organization. Throughout my life, I worked only in in-house commercial organizations, many in India, some of the best known companies in India, and then here, of course, for the last so many years. I always say that don't get into any kind of dispute. Now, when I was young, I was very enthralled the moment a dispute came, and then the court process, litigation, etc. But when I try to, go beyond that, become quite matured, I thought that dispute is not a very ideal thing that as a commercial organization we will have, because I may win a case, I may win an arbitration award, but at the end of the day, I am losing a customer, I am losing a joint venture partner, I am losing my future joint venture partners, and at the end, there is news all over that we are a very litigious kind of entity. So it does not do any good for any commercial organization, whatever they may say, because the idea is not to make some money out of the process. Now it is easier said than done. I will try to tell you in next 1 minute, because Karishma already threatened, we have got only limited number of minutes available with us. I'll tell you like this. I have got great interest in developing relations. So when I negotiate with the other side, I don't take them as our adversary. I have to fight. So if you say yes, I will say no. If you say 1, I will say 1.1. That cannot be the approach. I'm only talking about multi-billion-dollar negotiations. So therefore, try to understand from where the other side is also coming from. Similarly, try to ensure they understand your viewpoints also. And once that happens, we are in perfect peace with each other, at least for the time being, to start with. Many times we don't follow that. When we develop know your customer, know your partner also very well, what they want, what they don't want. That is what I do every time, try to understand the other side, so that, major dispute does not feature. Then come the brass track reality when you are negotiating a contract. Make it as clear as possible, because I have seen in my life defective contract is the creator of all disputes, very bad for in-house legal team, but very good for whom external lawyers, no doubt about it. So therefore, try to see the contract drafting, whether we can make out a draft as clear as possible. Your responsibilities are known, my obligations are known, and the matter can be sorted out. If there is a dispute, I can give you hundreds of examples in my life where in most of the cases, defective contract only brought all kind of miseries with the people. So that, ultimately you are fighting wherever. So it is very important to draft a proper contract. Third thing, what I can say, I'm talking from in-house perspective, make it known to your people that we have entered a contract. Now, I am in the midst of a organization which has got 200,000 people working in 50, 60 countries around the world. So it is a very, very difficult job. We are not a small setup. But you have to make sure this contract applies to whom, go to them, explain the nuances of the contract, and also try to train people that how you can really pick up the symptom where you feel disputes may arise. And then you prepare your own escalation process. The moment you smell that there could be a dispute that is brewing up between two people, because most of the time dispute arises because I don't like the other guy. It is a purely personal. This also creates hell of a lot of problem in terms of dispute. Then I must know how to escalate, at what level, so that the dispute can be nipped in the bud itself. So that kind of mechanism should be available. That's why many companies, especially in the West, they have developed their own dispute resolution policy, how disputes can be resolved to a great extent. Mind that while a dispute is going on, and we talk about mediation, I was attending the earlier session, very nice session, mediation, when starts, when does not start. Mediation should be there all the time. There is nothing called now let us start the mediation. So therefore, try to avoid the dispute, and then when a dispute starts, address the dispute, try to resolve it at a different level so that you don't get into mediation, arbitration, litigation, and whatnot.
Thank you very much. That was quite insightful. So, have a dispute resolution policy in place for organizations, and also educate those within the organization about how it works so that they know how to escalate within the organization. And also know your partner. I think that is what brings both parties to the mediating table. So thank you very much for that. There was one thing, Mr. Mukhopadhyay, that you said, and Fraser, I'm going to come back to you for the drafting of the contract is what Mr. Mukhopadhyay spoke about. But do you think that one can introduce any sort of specificity in the arbitration clause?
Yeah, it's always struck me that arbitration clauses are not very often used in a very imaginative, creative way. And it goes back to the discussion on the last panel about, is arbitration just court light? And I remember when I first qualified as a barrister, I was talking at some conference to a solicitor who specialized in arbitration. And she said, you do litigation, do you do arbitration as well? And I said, well, I haven't, but I'll give it a go. It's just like court, isn't it? Except you get to sit down and you get to have biscuits while people are speaking. And actually, the last 15, 20 years of my practice has very largely confirmed that impression. Most commercial arbitration is just a slightly more or less efficient, more or less informal method of adjudication that you'd recognize from court. It seems to me sometimes that's quite right, that's fine. People just want a private court. And if that's all parties want, then familiar arbitration is fine. But there will be other contracts where you have a joint venture partner, for example, who you genuinely want to commit to a long-term relationship with. And it seems to me that actually the last thing that you would want to do there is get in front of either a judge in a wig in a courtroom or someone who looks very much like a judge and may well be a retired judge in an arbitration center. And so for that sort of clause, and I've very rarely seen these, but I think there's scope for them, why not have a clause which says that the arbitrator will not just resolve disputes in a contractual way, but will have his or her own discretions to adjust pricing, to adjust the allocation of risk by reference to standard principles that could be set out in light of changing circumstances, or who can direct changes to a relationship for an orderly wind down if the arbitrator decides, according to the principles in the contract, that that's required. Why must it always be an adversarial breach, loss, damages situation? I'd be interested in others' experiences, whether perhaps that happens in other arbitrations and it's just not people like me who are instructed to argue them. But I've seen so many cases where nobody wins except the lawyers and the arbitrators. And I wonder whether if those people had thought about how they might end up when they were drafting their clause, they wouldn't just have adopted a boilerplate clause. They might have actually thought, how can we design an arbitrator's powers that can help us find a solution if we need one, rather than just resolve a dispute.
Thank you, Fraser. I think that adequately covers how can we be a bit more creative about the powers that we give to the arbitrator. And this takes us back to what Chief Justice Suryakant said this morning about party autonomy and really using it in the spirit of the arbitration rather than to orchestrate the outcome of the arbitration. So thank you, Fraser, for that. And we move to Amanda. Amanda, you have phenomenal experience. You run a company with about 1,500 experts. Can a forensic investigation make the parties see the writing on the wall? Can a forensic expert really coerce a settlement? or at least nudge them towards a mediation?
Well, thank you, Krishna. I think this is a really interesting subject, and you know, we're really talking about sort of how do we change the overall landscape. And once the facts, of course, become clearer, it really affects the behaviour of the parties in the dispute, and therefore the efficiency of the arbitration and the changes within it. So I think. Do they make the parties see the writing on the wall? I think, well, yes, in some cases is the honest answer, in that it can actually affect the psychological as well as the strategic. And when you look at the forensic investigations, what that really sets out to achieve is the clarity and the chronology as well as the quantification of the disputes that you have within it. Which can quite often, when you're starting on the process, actually be clouded by particularly the narrative and the emotion. So how do you really cut through that to get to the true facts that sit within it? And the priority has to therefore be the what, and then it's followed by the how and the who. So to really get to the heart of that, you've got to start to really look at the facts and break those down in terms of the data that sits behind it, and the analysis is effectively at the heart of that, which gets you the forensic investigation that you need. It's quite interesting. So HKA publishes something called the Crux Report, and we look across a whole number of disputes, around 2,200 projects, valued about 2.43 trillion, which is just phenomenal when you actually start to look at how that data can be used around sort of some of the core root causes that really affect those disputes time and time again. And indeed, when we look at the failures of what's happening there, it's usually the same failures that keep occurring around process, communication, and indeed documentation. So that's where you need that ultimate forensic analysis to sort of bring that to the fore. And what you've got to really think about is, you know, is that when you're doing that forensic analysis, which can show both the strengths and the weaknesses in your case, actually, do you want to share that information, or is it something that you keep internally? And of course, if you're able to share the information between the parties, it can quite often change the imbalance that you have that sits between them. So you're filling the gaps by that analysis. But equally, if you're actually keeping it internal, what it can do is sharpen the strategy and reduce the litigation risk, because then the decisions are based absolutely on the facts and not the assumptions. And for me, that isn't about coercion, it's actually about illumination. So forensic investigations don't force the settlement, but they do make the likely outcome more viable, and it's how do you get to that viability at the end of the day. Similarly, within RICS, the Dispute Resolution Service really looks at where neutral evaluation and expert determination often prompts the parties to recalibrate their position and come to the table, you know, with an open mind and to really sort of like think about the process long before maybe an arbitration actually becomes necessary. So do they actually look at improving the efficiency of the arbitration? Absolutely, they do. They narrow down the issues in terms of where the focus needs to be. I think they also look at reducing procedural sprawl, and that's a really important fact to bear in mind in terms of how you're taking things forward. But also, I think when you've got that forensic data, it can quite often prevent any late surprises in the process. So really, the answer to both questions is yes. It should be, not because forensic investigations coerce anybody, but they really get to the heart of exposing what the reality is that sits behind the dispute. And ultimately, they're not just evidentiary tools, they're engines of dispute resolution efficiency.
Thank you very much. So I think the panel is on the same page in relation to the narrowing of disputes, which can be done, it seems, in a number of different ways. It can either be done by bringing in an expert at an early stage, or by having mediation resolve a few of the issues in the matter, or educating their own, as Mr. Mukhopadhyay said. So just a couple of last comments. Nitish, one from you. What has worked? Can you give us an example of some of the cases that you or Trilegal did during the course of last year where it's worked?
So I'll give you an example of a matter that I did 2 weeks back. So that involved, so there was a suit filed in India. My client was an English company. They were implicated as a defendant. We kept fighting on whether the service has been done properly or not, a convention and all those things. And then we reached out to the other side that can we resolve this by way of mediation, right? The clients were sort of, I mean, they said, yes, please try it, but our experience has been, India, this doesn't work. So we said, I mean, please allow us to sort of try this, right? We had, I think I had 2 calls with the other side, a lawyer, and they said, okay, give us the proposal. We requested the court, please appoint a mediator. In one sitting, we were able to resolve that matter. And there were other defendants, but qua us, the mediator prepared a report and said, I'm submitting to the court, matter got resolved. So the client didn't have to file anything on merits, no evidence, no trial, because they were sort of like, who will be the witness? Will our employee from UK have to travel? What about the cross-examination? We were sort of able to resolve everything, right? Just to give you another example, apart from mediation, so earlier this year, the Supreme Court of India, it laid down a landmark judgment in relation to the enforcement of foreign award. Trilegal successfully sort of represented the parties there. The Supreme Court for the first time laid down the doctrine of transnational issue estoppel, which is mostly, I think it's followed in England and in Singapore. First time it's been laid down by the Indian Supreme Court. They said at the stage of enforcement, sorry, don't even talk about the merits of the case, right? They've gone to a different extent altogether, right, in terms of how things have changed. I mean, of course, we have a long way to go. But be it court litigation, mediation, arbitration, I mean, my experience has been, and that's basis sort of the matters that we do, is that if you have that right approach strategy, you are able to sort of navigate, find solution, and get that sort of commercial solution to the client. That's what they always look for.
Nitish, one last comment from the business side of things.
Thank you, Karishma. I mentioned that as a business house, we are not in the business of, getting into disputes, spending money, etc. We have got better jobs to do. Now the issue is that you can't avoid the dispute. What I'm giving you a practical example, being involved in such a global organization, first is we look through the contract. If it can be drafted properly, it will be good for us. Second thing, at every stage, if the relationship is very critical, you identify people who will be responsible even for maintaining the relationship while it is going on. That is what we do for our very big joint venture, etc. Third thing, what we do is that even when a dispute comes, we should have, this is where, we are only talking about mediation, arbitration, litigation, and whatnot. But the desire of the parties are extremely important. If I'm too much keen that I want to resolve my differences with you, I will go whole hog to see. Fourth thing, mediation, please do it sincerely, not should be some kind of tick box kind of thing. Different layers, let us give it a try. And finally, if nothing works, go for arbitration, not for litigation. And even when the arbitration goes on, we always try to see an opportunity where we can settle the issue. This is how we resolve disputes.
Thank you. So it seems that the best dispute is the one that you never have. For the others, you resolve them efficiently with all of the tips and tricks that this panel has given to you. Thank you very much.
That has indeed been an unrelenting yet brilliant array of conversations throughout the day, marked by depth, diversity, and engagement at every stage. As we culminate this conference, ladies and gentlemen, thank you for being with us on this fine Friday. and for making this conference such a vibrant and intellectually engaging forum. While the formal sessions conclude here, the deliberations, we're certain, will continue well beyond this hall. We now warmly invite you all for a sumptuous lunch. Thank you. And we need a joint panel picture. Do we have the photographer around? Yeah. Just 2 minutes. Can we have the backdrop on the screen? Ravi?